Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous the insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Thanks for coming to hang out with me today. Today is Thursday. Today's Thursday, December 11th, 2025. Court started a couple minutes early, so we're going to jump in and see what's happening. Today is day 9 of the Brian Walshe trial, and it is expected that the defense will begin its case today. The state rested yesterday, and I still have yesterday's banner up, so let's get into court and see what they're talking about. I imagine they're going to be discussing jury instructions right now, as well as whether or not lesser included offenses will be included on the jury verdict form, because I did the research last night. That is 100% up to the judge. It doesn't matter whether the defense requests it. It doesn't matter whether the state requests it. It is up to the judge to decide whether lesser includeds will be included on the verdict slip. They may not be talking about that today until the end of the defense case, but murder 2 is usually always a lesser included of murder 1. And in Massachusetts, murder 1 requires deliberate premeditation and or extreme indifference and cruelty. And anything that is not murder 1 is considered murder 2. So that will remain to be seen. I'm not sure if that's what they're talking about right now, because I was in hair and makeup and I didn't even get done. So let's get in there and see what's happening right now. Good morning, Judge Freniere, also known as our Judge Susan Lucci. Here we go. We're not too far behind.
You are. In the matter of the Commonwealth versus Brian Walshe, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Morning, Your Honor. Larry Tick.
Morning. We need the defendant.
I'm sorry, this is the beginning, isn't it? Somebody said start from the beginning. This is the beginning. There's the clock. This is the beginning. We're starting from the beginning. Don't worry.
In the matter of the Commonwealth versus Brian Walshe, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Coniff for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yas for the Commonwealth. Morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Morning, Your Honor. Larry Chip.
Morning, we need the defendant. Thank you, Claire, for no spoilers. I appreciate it. Thank you, McKee 12. I would appreciate that too, because as you can tell, I'm not in the mood. I'm not in the mood today. Oh, gee, thanks for coming in and spoiling it.
Present in the courtroom.
Thank you, Madam Clerk. Get you a little time out.
All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not?
Okay, Brian Walsh will not be testifying. He will not be testifying. There you go. Do that again.
An initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not?
Nope. Guess they think they don't need it.
All right.
That's a bummer.
Does that moot every issue that I researched last night?
She's not happy she did all the research.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record.
Hey, wow. So no witnesses today. The defense is not even going to put on a case. They're not even going to put on a case is what he said. So closings are going to be tomorrow. We're going to have a charge conference after this. Happy Thursday, everyone. She did research last night. She doesn't seem to be happy about it because she seemed to do a lot of research on whether or not his guilty pleas were going to be allowed in if he testified. And I think that the basis for that is that perhaps the defense thought, based on the way she was going to decide about whether his guilty pleas were going to come in, they decided, or Brian Walsh decided, because it is his decision, after all, in the end, that he will not testify and that they will not put on a case. And they had an expert and they had forensic experts and everything. Let's just hear that again, because the judge did not seem to be happy about all the research she did last night. She said, everything I did last night is mooted. Yes, it is. Okay. For those of you who are just tuning in, we had to start a few minutes early, and here we go.
Today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for two reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay, so just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right, on the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway, in substance, maybe not exactly as it's presented. Those are items number 319 and 320, Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right. And after consulting with the Commonwealth this morning, they have no intention. They told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit.
That's a classy move by Greg Connery, because he is perfectly permissible. He's perfectly allowed to get up in closing and say, listen, the defense promised that you were going to hear from Brian Walshe, and you didn't hear from Brian Walshe. And the defense told you that they were going to prove this to you and prove that to you, and they haven't proven this or that to you. And Larry Tipton said, the motion is irrelevant because they've told me they're not going to get into that. And that's pretty nice of them, to be honest. They don't have to be like that. We've seen some scumbaggery with special prosecutors in the Commonwealth.
Of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like him sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Okay, we're a little behind. We have a little bit of room to move.
Oh, yeah.
So the defense will be resting today when the jury comes in, and then we will go to a charge conference. The defense is going to rest. They're not going to put on a case. Brian Walshe is not going to testify. The judge is now going to speak to Brian Walshe to make sure that he understands that he has every right to testify and to make sure that it is his decision not to do so, and that is called a colloquy.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, Have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicine?
Correct me if I'm wrong, but I believe that this is the first time, other than the recorded statements that we listened to on day one of this trial, that we have heard Brian Walsh's voice. Let me hear it again. Yeah, the first time ever. It's more soft-spoken than I thought.
Hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
I stand corrected. We did hear his voice when he pled guilty, but technically, that was before opening. So technically, it was before the trial started. It's a strategic decision on the behalf of the defense. Could mean a couple of things. Could mean, number one, they don't think the Commonwealth has proven its case, and so therefore there's no need for them to put on a case. Could be that they're preserving all of their rights on appeal and they don't want him to testify because he could say things that could, you know, screw him on appeal. Could mean that they've been out there looking at the chats and looking what all of you are saying, and that many of you do not think the Commonwealth has proven its case. I think it was 70% of you yesterday. And yet we still don't know what the judge is going to decide about lesser included offenses on the verdict sheet.
For your attention, you may be heard. Let's have a call from Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
God save us from the Commonwealth.
Morning, jurors. Morning. Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Yes. Were you able to comply with my order that you not do any research about the case?
Yes.
Were you able to comply with my order that you not go on any social media or access any news media? Yes. And you still all have open minds? Yes. With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench.
There it is, defense rested. If you're just tuning in, you missed the whole preamble before the jury came in. Brian Walshe will not be testifying. The defense has rested. We will now go to a charge conference after the jury is excused and the attorneys are going to sidebar. And we're still a few minutes behind, so we're going to scooch right on through. Kim is not, our courthouse watcher, Kim is not in the courtroom today. I would do a fit check, but I can't see if he's wearing a cardigan again or if that's a suit jacket. It looks like a white button-down shirt.
I think the jurors, I think I've referred to the trial as I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth, all right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really two things that happens interspersed. I'll explain. The two things that need left to be done is I need to give you my jury charge, my legal instructions to you. And then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers about what they're seeking. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise to the court, please.
Jury's like,
Jurors,
yes,
close your notebooks.
we get the day free. We get the day free. And there's Brian Walshe. Is he wearing a tie? Let's see. Kelly Gorgeous Porges hair on point today. I don't know. Looks like Brian might have got a haircut. Let's everyone smash the like button while we're here because our day is not over. The jury's day is over. Our day is not over. I imagine we're going to talk about lesser included. We're going to talk about jury instructions. Okay, that in the mic paper shuffling is going to kill my earbuds.
a couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Wu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe. With the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that
I
transcript.
want that
Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mutlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I have had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that. I considered that as I was drafting the draft instructions yesterday, and I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions, and I made a mental note to go back to those this morning, but I didn't, frankly, have a chance to do that. Since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is, when I was scratching my head, saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics.
The way you
Who's
guys,
closing for the defense?
the way you guys feel that this court revolves around you and your viewing wishes. Chloe's mom says the defense could have rested yesterday and they could have worked on instructions. Listen, maybe the defendant Brian Walshe, who is entitled to a fair trial under the Constitution of the United States of as such America, wanted to think overnight about whether or not he's going to testify. It's very, very, very big. It's a very, very, very big decision to make. Many of you are very angry that you're not going to see Proctor. I hate to tell you guys, this trial does not revolve around you and what you want to see and what you think they should be doing. Some of these comments are hilarious. This is the hardest working judge that I have seen in Norfolk County. She wins the prize. Let's just DoorDash her a trophy. She was up all night working on this. She really cares. She really cares. And I really feel like she's going to be overturned on appeal. So kind of feel bad for her in that sense. But this could be a very strategic move by the defense. 70% of you yesterday did not feel that they proved murder at all. The poll was only on murder 1. Okay, you want Yuri. He's not coming. I hate to break it to you. I'm sorry. He's not coming. He's not coming today. Maybe you'll see him in another trial. Go back and watch the evidentiary hearing. Give me a rewatch on that because he did testify there. Maybe the defense is thinking they didn't even prove murder. I have a problem because if Brian Walshe does not if Brian Walshe is not the one to testify that he found her dead in bed, that's really the only evidence of that. And it's interesting because Larry Tipton said it in his opening. You're going to hear Brian say, here's what he did. He nudged her, he nudged her, he nudged her again. She rolled off the bed. There's no other evidence of that. The only way that would have come in was through his testimony. Rock Villancourt says, I do not accept this ending. I want Walshe to testify. And I want it now. It's like there's 7,800 Farouk assaults in the chat. I'm really sorry, you guys. I apologize on behalf of the court and on behalf of the defense. And somebody actually said, do you think it's because Larry Tipton is a public defender that they're not putting on a defense? And I'm like, what? Are you throwing shade at public defenders? Absolutely not. He is the most skilled public defender in the state of Massachusetts, in my opinion. And he's got a strategy. And it'd be foolish for me to try and tell you what it is. But I would absolutely tell you that he knows exactly what he's doing. And the fact that he is a public defender, in my opinion, has zero bearing on the defense not putting on a case. It's strategic. So let's see what else we get into. I'm not going to get into my whole research that Tom Kokanowski did for me. On Lesser Included right now. Shout out to Tom Kokanowski, who also said that in every case he asks for, here he is, one of our favorite Massachusetts defense attorneys. If you need a defense attorney for a DWI or anything else, even civil rights violations, he does civil cases too. Tom Kokanowski is your guy. He's got a cat named George Clooney and we love him so much. Tom said the defense has to decide whether to ask for the specific jury instruction about a defendant not testifying. I always do. We saw Tom Kokanowski in action in the Brian Camp trial in Hampshire County, and that was amazing. Brian Camp was acquitted. So let's see. I have a feeling they will. Larry Tipton is on his game, don't you think, Tom? All right, here we go. Thank you for coming to my TED Talk.
I am.
And who's closing for the Commonwealth?
Great.
Who's closing for the defense?
I am.
And who's closing for the Commonwealth?
Oh, I don't know who that was. Was that Ann Yaz or the third female attorney we haven't heard much from, except for she argued the required findings motion. Judge is like, I don't make overtime. I'm on salary, you guys. You're killing me over here. Working all night. Everything is fine over here. Says he's putting all his eggs in the appeal basket. You may be right. I may be crazy. But it just may be a lunatic you're looking for. Name that tune. Avila says, why are they being so nice to a murderer in their mind? Are you talking about the Commonwealth? Because attorneys grant each other courtesies all the time, and every defendant is presumed innocent.
The address of the,
until if and when proven guilty. And they have been very nice to Brian Walshe. I'm also gonna point out that they referred to Brian Walshe as Brian Walshe throughout this trial instead of the defendant. Remember in Karen Reed, and did they ever call Karen Reed, or did they refer to her as the defendant the entire time? So yes, every defendant is entitled to a fair trial and courtesies, shockingly, I know, and to the presumption of innocence until if and when proven guilty. And many of you in the chat do not feel that they've proven premeditation and or perhaps even a murder. Yes, it's Billy Joel. You may be right. Thank you very much.
Refuge Center, 300 Forest Street, Peabody.
Yes, Your Honor.
What about Peabody? Hold on.
The address of the, Refuge Center, 300 Forest Street, Peabody.
Yes, Your Honor.
She's detail oriented. I like it. She knows the case. Do you remember when Judge Cannoni didn't even remember that Higgins was a witness? Right. Buzzsaw says even the kids called Karen Reed the defendant.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it.
Hey, Tom, he did it. He did it, Tom.
Commonwealth seeking a mode of instruction.
Yes, Your Honor.
Oh. I haven't seen proof of motive. Some of you some of you have. We have a very split chat on this.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? 88 Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27.
She threw a little shade.
Some
to
evidence
MCLE.
suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So,
it should have been.
so just take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned
At least she's laughing now.
quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself.
See, even judges don't know everything. Even judges are always learning. Always learning. MCLE is continuing legal education, and I assume the M is from Massachusetts. I think she's going to use the SJC instructions.
I'll take that object of the killing out. All right, so let me get these to you, and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law, but I'll get it to you.
Thank you, Your Honor.
All right.
I missed that last part. I just got to take it back.
If you need a
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law, but I'll get it to you.
Thank you, Your Honor.
Yes, the defense is not going to put on a case. They have rested. The jury is gone for the day. We are now talking about jury instructions and how the jury is going to be instructed. And it was 9:30 then. It is now 9:45, which means we're only 15 minutes behind. We have a lot to talk about until they come back. And a lot of really interesting comments in the chat. And I think what we should do, since it's not very long, is watch Larry Tipton's opening again, because the Commonwealth has said they are not going to tell the jury, you heard Larry Tipton say this in his opening, and this, and this, and this, and this, and this. And he didn't prove it because the defendant didn't testify. They're not going to say that. Exactly. Good. Hold on. We got some good comments here. Thanks for getting me through my work days, says Corrupt in Massachusetts. Thanks for hanging out with me for 18 months. It's been a long Long time that I've been getting you through your work days, and it is my pleasure. Julie Jensen, thanks for your 10, said he shouldn't testify. I said that yesterday. The state hasn't met their burden, and getting him on the stand would make it worse for him. That is a fine point. Thanks for your 10. Charles says, Tipton, quote, once she allowed the searches in, we were screwed. Thank you, Charles. I mean, that's Charlie. Thanks, Charlie from Down Under, for your 5. Music to My Soul says, so not even Brian Walshe has an ego as big as Alec Murdaugh. I really thought that he was the type that would want to tell his story, because really he's the only person who can say that he found her in bed already dead. However, maybe the defense is going to bank on the medical examiner's testimony, because remember, the defense did get a lot out of the medical examiner about otherwise healthy people suddenly dying, right? And also, her COVID vax card was found in the dumpster. I don't know if he's going to bring that up, but that could be something that hangs somebody on the jury. In my opinion, I Love Sarcasm says, do you think they always intended their expert witness to be the Commonwealth's medical examiner? See, that's what I'm saying. No. And I have their witness list right here for you, because they had it pulled up so that we could look at it anyway. And I went back and looked at the witness list last night, and I don't think Diana Walshe was ever on the witness list. So hang on, let's take a look at it. Let's take this down. They're coming back. What did they say? 10:30? And if they need until 11, she will give them until 11. Here's the witness list. And this is it was a combined witness list. So this very small list on the bottom here, it was the defense prospective witnesses. And of course, the defense could call anybody else on the Commonwealth witness list as well. But here's who they had listed: Dr. Stephen Lakin and Joel Skoletsky from CFOS Corporation. And Priya Banerjee, who I believe isn't Priya Banerjee, is she a doctor? Her name is so familiar to me. I don't know if she's on Court TV a lot. I'm not sure exactly what her specialty is, but she's with Anchor Forensic Consulting. And another forensic expert, Dan Faria, and Stephen Verino. His name may be familiar to you because he has been a part of some of the taint teams in the Karen Reed case. Tracy Miner, who was Brian Walsh's white-collar attorney, Michael Proctor, and Tim Creamer. I'm not sure who Tim Creamer is, but these are the people that were on their prospective witness list. They have chosen strategically not to put on a case at all, because perhaps they don't think the Commonwealth has proven its case. And here's the list of witnesses, the whole witness list in its entirety. And many of these people were never called. It's a joint witness list. I Love Sarcasm. No, I think, listen, a trial is a living, breathing thing, right? And it changes from day to day. And yes, you prep for things that don't happen. Remember, David Yannetti said he prepped 100 hours for Brian Albert's cross, and Brian Albert was never called. It happens. That's part of the job. It's what you sign up for. You prep for things that don't happen. You're unprepared for things that do happen. The Commonwealth might have expected the defense to put on a case, and then they're like, holy crap, now I gotta go draft my opening, and that takes a long time. It takes a long time to get everything in there, to go back and review your notes, to go back and maybe they even use some of the video that's on YouTube to go back and review the testimony. Maybe they look at Long Crimes feed or Court TV's feed, because it's easier than getting transcripts. That's for sure. Although they don't get transcripts of the sidebars because they're not, you'd have to order those. I want to know who wore the medium Tyvek suit too. I have so many questions. Hold on. Maybe Larry Tipton thinks that in his brilliant closing, because we've seen him close before. We saw him try the Penny McGee case. That was a bench trial in front of Judge Cannoni. He was brilliant. She was acquitted by Judge Cannoni, who did not even need to take a timeout off the bench. Happy birthday to your mom. New Hampshire woman's mom is turning 100 today. What's her secret? Tell us her secrets. Happy birthday to your mom. That's awesome. So as you see here on this first page of the updated potential witness list for this case, there were many, many keepers of records. Many of them were called from Lowe's and Home Depot, TJ Maxx, Vin and Liquors, Stop and Shop, Chatham West. We did see, right? That was what we saw yesterday with the very grainy video near the dumpster. Chestnut Glen Apartments in Brockton. Did we see that? We saw a dumpster outside the liquor store, and it looked like he had a bag that was relatively small. And I know we saw the keeper of records for the Swampscott apartment building. Here's some civilians on the list. We saw Peter Capizzoli. He was the landlord of their house in Cohasset. I think we saw Ashley. Did we see Ashley Chimino or from Bar Method? Janet Cotter. I think we did see her as well. Julie Basler, Holbrook. We saw Hugh Dunleavy, Will Fasto, Suzanne Garland from the Bar Method. Some of these people I don't recall. Alyssa Kirby. Did Alyssa Kirby say that she lives in Israel now? Because I remember this when the trial was pushed the first time and Brian Walshe was sent to Bridgewater State to test him for competency. But I don't recall her saying she came in from Israel this time, but they did need to plan a lot of travel for people. MSP Crime Lab personnel, they listed just about every person that works there. And I think we might have heard from every person who works in the DNA unit in the MSP Crime Lab. Cohasset PD, we heard from Officer Greg Lawrence, and we heard from Officer Patrick Reardon, I believe, and Detective Harrison Schmidt. There are 3 others that we did not hear from. We heard from a federal probation agent, Marlene Ramdahal. She testified yesterday about Brian's schedule and when he was allowed to leave the house. And here's all of the MSP that we did not hear from. And a lot of you are very disappointed and heartbroken. One of whom is Yuri Buchanan. Also of note on here that you may recognize from other cases, David DeChico was not called. They might have realized that to do so would be opening a can of worms, potentially. They also did not call anybody on this whole list except for Garino and Keefe, but all they did was forensics, downloading the phones, right? They did not respond to the scene, did they? Was any NMSP trooper called who responded to the scene and searched the house? Because I don't recall that. I have to go back to my notes, and admittedly, I have an entire legal pad and a half full of notes. Familiar names who were not called: Lieutenant John Fannings, Kikowski, Sergeant Keith Pantazellos, KP, Trooper Kathy Prince, Brian Tully, Colleen Crawford of the video unit. The only medical person to testify was Dr. Richard Atkinson from the Office of the Chief Medical Examiner. And he testified he did not find any human tissue. But Larry Tipton was able to get out of him that people do, in fact, die of sudden death, and it is not uncommon. Jen says, this is like a good book that you can't put down, and then you get to the end and you're like, what WTF? Mama Cass, thanks for your 20. Says, good morning. You may have answered this before, but can the Commonwealth add in the lesser charges now? Were there already lesser charges? Well, it's not up to the Commonwealth to add them. It's not up to the Commonwealth. It is not up to the defense. In the end, the judge is the decider of whether or not lesser includeds are included on the verdict sheet. And so if the evidence warrants it, if in the judge's determination, the evidence shows that the jury could reasonably come to a verdict on murder 2 or manslaughter, perhaps she is the one who makes the final decision on whether or not the lesser includeds are going to be available to the jury, and we have not heard anything about that yet. So the definition of murder one, well, I'll pull up the research on that after. So technically and typically murder in two is by operation of law, murder two is a lesser included of murder one, because anything that is not murder one is murder two. But manslaughter is not always included. And so we just don't know yet. And I just don't know what she's going to decide, but you can bet your ass she's done hella a lot of research on it. Thank you for your 20. Oh, Ginger, thanks for your super sticker. And on top, thank you for your super sticker. Good morning, Iceman. Iceman says, Mel, I'm sure I'm in the minority, but last night when I was home, I thought the defense needs to rest because the Commonwealth hasn't proven that he murdered her. He cleaned it up, but they haven't proven that he murdered her. Listen, all of the questions that we have, the jury might have too. And if they're back there thinking of alternate theories and who else might have done it, isn't that reasonable doubt? Thanks, Iceman, for your thoughts. You guys are very critical thinkers, and I love that about my chat. My chat, my choice. Gigi's got your back says, I have the flu. I'm watching from bed. Thanks for covering this. I'm sorry, Gigi. I hope you feel better. Hope you can DoorDash some chicken noodle soup. Or matzo ball soup is really the best when you're sick. Thank you for your super chat. Elizabeth says, I have been here much longer than 1 month, and I love the cupcakes. Thank you. Sandy D gifted 5 memberships. Thank you, Sandy. You're amazing. Need Mock, thanks for being here for 15 months. And welcome to Friendly Farm Girl, who became a member. Robin says, I want to commend Mel and all the great cupcakes for your reasonable and thought out comments. Saw another chat yesterday and they all got it wrong. You were the smartest chat with the great Mel. They did not prove it. Applause. But you know, there are always people on the jury. And I saw this comment too. And it says, the prosecution has put on a circumstantial case at best, and defendants are convicted on circumstantial evidence all the time, right? Not everyone is as critical thinkers as you all are. And then somebody else put in the chat this comment. Oh, well, this is what I just addressed. JP Zone now said the lawyers are prepared for Brian Walshe to testify. What a waste that must be. Tough for a lawyer to do all that work and you can't use what they have prepared. Doesn't seem fair. Well, you know, life isn't fair. And the trial is a living, breathing thing. And like I pointed out, David Yannetti prepped 100 hours to cross Brian Albert and it didn't happen. Yeah, it's a bummer because you really want to do it, but that's the way, that's just what happens. Trial's a living, breathing thing. And then Texas said, and this, kids, is why DV continues and how they get away with it. Lessons never learned. Well, I haven't heard any evidence of DV in this case. Have you? Because maybe I was asleep that day. Did you hear any evidence of anybody testifying that Anna was afraid of Brian, that he had physically and or verbally abused her in any way, shape, or form? Because I was absent that day, I guess. I didn't see that at all. And so while I agree that somebody like Jesse Butler in Oklahoma, who got a slap on the wrist after graping 2 girls from his high school so violently that one of them was 30 seconds away from death, according to her doctor, that he's going to get a year of therapy and walk away scot-free because perhaps his father, who used to be connected to the OSU football team, has some pull. That is a very different case than this because I didn't see a bruise. I didn't see fear. I heard a lot of testimony about Anna wanting her family to be together and being at her breaking point because of all the commuting that she was doing and all the travel, and she was exhausted and she wanted to be with her kids. She wanted her family to be together. But I never saw any evidence of DV or heard about it. And so I think that comment's a little bit misplaced for this case, but that's my opinion. Jennifer says, well, without any testimony by the defense, I don't buy that a seemingly healthy Anna died suddenly. So that leaves me with believing that he killed her. Not sure about first degree, though, but maybe. Well, if you've been watching the chat for the past couple of days, there are so many people in the chat who have shared stories of loved ones of theirs and friends of theirs who have seemingly just dropped dead out of nowhere. And so it happens. Brian's not going to tell us that it happened, but the medical examiner did say that it can happen. But again, there could be a juror who thinks that exactly like you. I don't believe it. There's no way that could have happened. But we also heard testimony from her friend that Anna wasn't feeling well. She didn't look well. I don't remember. She said she didn't look well, but she said she wasn't feeling well. And then her friend Alyssa came down with the flu, and she was so sick that she didn't even respond to Brian's text for something like over 24 hours. And we know they were together for 6 hours at the karaoke dancing bar. I don't know what a karaoke dancing bar is, but I'm just saying, said, yes, where are the buckets? Where is Anna? How can they have all this video of him throwing things out, but no sign of the buckets or Anna? Well, that's the thing. And I was thinking about this last night, and I was racking my brain. And I said to myself, I said, they've got Brian Walsh's total phone extraction. They have his location data. They know every single place that he went on each of the days that he went around doing his chores. And they got surveillance video from all of those places. And so if they know exactly where he was and exactly what he was doing and exactly what he bought, did they go to the other places that he went to? Where's the intellectual curiosity about finding other things? Or were they just like confirmation bias? He must have done it. He obviously did it. So we don't really need to dig a little deeper. Where was the curiosity about finding Anna's body? And so if they had all of that information, the phone was lost for a day or so. Yes. So, but the information that they got, the location data, was from the other phone that he had with him. It wasn't clear to you guys. And we did this in pretrial. He had his son's phone with him. His son's phone was in the center console of the Volvo when the police came to his house on the 4th. And they took both those phones and the iPad, right? And they did total phone extractions, even though, in my opinion, the consent agreement clearly said you can only look for communications between Brian and Anna for this finite period. So they had it. Refresh my recollection of when he says he got his phone back, but then they have evidence that it was plugged in and unlocked. I think the jury has a lot to talk about. I don't think that it's going to be a quick verdict. I think that they have a lot to talk about. And then Marie says, we have the benefit of your critical thinking and commentary. The jury may not be thinking the way we all are. And that's true. That is so true. And Ethel Owen says, I agree, Melanie. They didn't want to investigate. They had no drive to even put all the searches together from the different devices or click the searches to see more. Right. Right. And you, lady in the back, says, if the investigation was legally solid, the Commonwealth would have called the MSP, but they didn't. Robin says, I want to commend, thank you very much. I want to commend Mel and all the great cupcakes for your reasonable and thought out comments. Saw another chat yesterday. They all got it wrong. Applause. Thank you for your 20. I think I just addressed that. And Sandy said, I love Melanie's laughter at the outrage comments. I know, everyone was so mad. It's like, you guys, listen, first and foremost, this case is about Anna Walshe. May she rest in peace. If she is indeed dead. A lot of you think she may be out there somewhere and that this is a long con on behalf of both of them. But my heart breaks for those children. No matter what, my heart breaks for those children. And again, this is not supposed to be our entertainment. That said, is it disappointing that the defense is not putting on a case for you guys? Yeah, I get it. I get it. Is it disappointing that Brian Walshe is not going to take the stand and pull an Alec Murdaugh and, have snot running out of his nose and stuff? Yeah, we all wanted to see it, but he's not going to. Thanks, Nandy, for being with me for 14 months. I mean, just read the chat. People will tell you their stories of their friends who just passed away suddenly, otherwise healthy. They didn't bring in a doctor of Anna's to say that Anna came in for a checkup recently and she was totally 100% healthy. Nothing wrong with her, right? Eileen says the probation officer said his mom was staying with them after surgery and he drove her home on January 1st. No, the probation officer said that that's what Brian told her. See the difference? The probation officer said, so this is your comment is the probation officer said his mom was staying with him after the surgery and he drove her home on January 1st. No, the probation officer said he requested time to leave his home to drive his mother home after surgery on New Year's Day between 3 and 9. Do you see the difference? We know Brian Walshe is a liar. And that's a good question, Eileen, because a lot of people are wondering, was Brian Walshe's mom in the house on New Year's Eve? Jem says no. But do we really know? We also know there was a Legionnaire's disease outbreak in one of the buildings that she was managing, that she was in all the time. Could you please replay the prosecution opening too, so we can see if they did prove what they claimed? Okay, we will. I will take that under advisement. They're coming back when at maybe 10:30. Thanks to Next Gen for your super chat, and Lettero Babetero is here. What a difference when you have a fair judge. OG23, OG 23 months. Lettero Babetero. Thank you. It's a big difference, right? Be Rad for real says, I'm finally a free person after 28 years. I've been exonerated by the state. No more criminal records or charges. Just wanted to pass it along. Congratulations. Congratulations. Thanks for your 10. I don't know what you're referring to, but I guess congratulations are in order for Be Rad for real. Thank you. FS Coelho says he wanted to be a con man, but he was too dumb to get away with it. And I think Anna finally voiced how drained she was with the limitations of him. You mean of him not being able to go to DC? That could be. He could have found out about the affair and snapped. I'm willing to believe that also, but I have no evidence of that. But I could see that happening. But we also know that he used her credit card to buy a whole bunch of sports memorabilia. And I don't remember the exact amount or anything, but that my opinion was he was looking for his next con. His next con on sports memorabilia, even though he had not yet been sentenced for the con that he was already waiting to be sentenced on. Thank you for your 5. Shine on you, Crazy Diamond. Thanks for your super chat. One of the most interesting pieces of evidence is the broken necklace. When and why does a necklace break? It's not that easy. For me, the necklace is the only piece of evidence that could indicate what really happened. Well, thank you for reminding me that somebody sent me the blurred out picture. So let me pull it up for you. Because this is from her Instagram. And I think I know why it was blurred out now. Hold, please. Thank you, Kendra, for sending this to me. Shout out to Kendra. There was a broken necklace in Sandra Birchmore's case as well. This is the picture that was blurred out. Oops. Come back, come back. Do you think maybe it was because of the giant ring? Hold on. See the giant ring on her finger? The purpose of that picture was to show that she was wearing this black jacket, right? See the giant ring? And this is a post from Anna's Instagram from October 7th, 2022. And her hashtag is DCA to Boston, Delta, and have a great weekend. The ring is huge. Was that the deal for the $128,000? I have so many questions. Thank you for your super chat, Sean, on your crazy diamond. Spacey Stacy says, will we ever see Proctor's texts after this trial? I don't know. No, they're under protective order right now. It has been ruled by Judge Krupp, though, that they can release them to other organizations who have asked for them. But they're locked down pretty tight right now. But you know how these things go. Eventually, somebody always leaks them. And so I think eventually they will make the rounds. But after this trial, they will not, because they're not in evidence, number one. And number two, they're protected under a protective order by Judge Krupp at this point. Kazi's Thesaurus is here and says he has small children. They love to take and play with phones. So it being missing for a day is not that surprising. I agree. And it had happened before, I think. And we never heard from the nanny. We don't know where her ring is. No. I really wanted to hear from the nanny, because I thought the nanny would have all the tea about whether they got along, about whether they were fighting all the time, about whether she ever heard arguments, about whether Anna ever had any bruises or black eyes. Like, none of that stuff ever came in. And that's the ring that I just showed you, the ring from the dinner party. Hold on. But is it consciousness of guilt that he took his son's phone with him when he went to do all the errands, or could it just mean that his phone really was missing, so he took his kid's phone? Thank you, Kazi's Thesaurus, for your 5. Catherine said, premeditation. Brian lied to the probation officer for the 3 to 9 p.m. window on New Year's Day, then lied to Anna about taking her to a special dinner that night, according to the nail lady, to keep her from DC, in my opinion. I think he did have a reservation, right, for the noodle bar. And that is the way that some of the jurors may think. And I want to know more about the mother's surgery. I mean, I remember when we went over something in pretrial, maybe it was the lawsuit by Capizoli against Diane Walshe, that the reason they were renting this house was so that they could take care of her after this surgery. And so did something happen? Was her surgery canceled? And he had already put in for that time period. But yes, I can see completely how putting in for those 6 hours, someone could think he had to put in like a week before, that he was planning to do this, and he was planning to do it that day because he would have all that time to get rid of all of the evidence. And that's a great point. Thanks, Catherine, for your super chat. Rachel, thank you for your 10. Says, I have this feeling I can't shake that his mom was involved. She didn't like Anna. A lot of people in the chat are saying that. Please do not reach out to her in any way. Thank you, Rachel, for your 10. James says, I'm disappointed, but I'm not seeing a defense, but always happy to be here with you, Melanie. Oh, I feel the same way, James. Thank you so much. This is great too. Phases of Leah says, what about the son saying he saw Anna leave? This is something that's going to haunt me for a very long time. This was not brought up at trial, but those of you who know, because we read all the pretrial motions and we watched the evidentiary hearing, Yuri Buchanan interviewed the 6-year-old boy. I don't remember exactly which day it was or during which interview. It might have been on the 4th. Yuri Buchanan interviewed the 6-year-old boy. Diana Walshe was at the table. I remember they did it at the table. And Yuri Buchanan testified during the evidentiary hearing that we watched about the motion to suppress the improper searches and the fruits of the poisonous tree. The 6-year-old boy told Yuri that when he came down early in the morning around 6 a.m., his mother was sleeping on the couch under a blanket in her pajamas, and that his iPad was broken and that he wanted his mom to fix his iPad. So he gave his mom his iPad and she fixed his iPad. And then he said his mom went upstairs and she came back down dressed in her regular clothes with a 2-foot-long duffel bag, and that he saw her leave the house and get into a taxi. That is what the 6-year-old told Yuri Buchanan. That was never brought up during trial. That haunts me to this day. That if that is not true and that is a lie, who coached that little 6-year-old boy to say that to the police? And then Yuri Buchanan said that the 6-year-old drew him a picture and gave him the picture as a gift. And then Yuri said the 6-year-old boy took his hand or something, grabbed him by the arm or the hand, and brought him to the basement door. That's what Yuri Buchanan testified to. And Cricket says, and that's why Buchanan wasn't called. So sad. But when the boy brought Yuri Buchanan over to the basement door, did Yuri go down in the basement to look? Because Brian had given them consent to look around the house. They had consent. That's what makes me think he's even a dumber criminal than I thought. He gave up his phones. He gave up the iPad. He let them search the house, the car. He let them do it all. He let them search the pool. He let them search everywhere. I just don't know. It's going to haunt me for a long time. Thank you for reminding me of that. Thank you, Nona, for buying 3 matcha lattes. I'm going to need them today. The defense rests. Now have a matcha latte. I'll have DoorDash bring it to me from Duncan. Catherine, thank you for your Venmo. Says for all your hard work. DoorDash is my friend too. Get so much of DoorDash. It goes everywhere for me. It goes to Home Depot for me. Brian Walshe could have had all that stuff DoorDash. He didn't have to be on video collecting everything on his list. Nancy, thank you for your 3 matcha lattes. And she says the defense begins. The defense begins and ends all in the same 20 minutes. Thank you, Nancy. I appreciate you so much. Elaine, thank you for your very generous 100 by Venmo. Says I'm here. Just covered up in Oklahoma. Thank you for covering Walshe. Looking forward to the defense case. I'm sorry, Elaine. I'm sorry to disappoint you, but there's not going to be one. There's not going to be one. A lot of this is going to hinge on closings. Will they be able to wrap it all up in closing to convince the jury somehow Brian Walshe did not murder his wife? What say you? Kia, thank you. I did see the update in the Gilgo case. There was a man in Florida who has been arrested for Peaches, who is now known as Tanya Jackson, and her 2-year-old baby Doe. Yes, I did see that. Haven't covered it yet, but apparently he was the father of the baby. We did speak about it briefly the other day. This is, we thought Long Island serial killer Rex Heuermann might eventually be charged with that, but they have made an arrest in Florida, and the man they arrested allegedly, apparently, is the baby of baby Doe, and that is very, very sad. But I don't know much more than that right now. Not a House defendant. Can the judge choose not to accept that the defendant is not going to testify? No defendant can be forced to testify. You have the right. The Fifth Amendment gives you the right not to testify. And the jury is not supposed to draw an adverse inference from the fact that you do not testify. The jury, and they're going to have that instruction. The jury is not supposed to come to the conclusion that because you didn't testify, you must be guilty, because you're afforded that right under the Constitution. So no. Good question, but the answer is no. Thank you for your super chat. Rachel, thanks for your super sticker. Real Steve says Marcy's shop tried this case. While we admire Greg Connor, if you know, you know, the Norfolk DA's office will be humiliated if they don't get a conviction. Guilty pleas aside, right? You're correct. And do we know Has the judge decided whether the guilty pleas are coming in yet or not? Or did she say she was going to go back and think about it based on the fact that he's now not testifying? We have 9 minutes until 10:30, so I'm going to wait and see if they come back at 10:30. If they decide to come back at 11, we will watch Larry Tipton's opening after that. Let's take a look at the research on lesser included, because we haven't heard anything. We haven't heard any talk about that yet. But I know that this judge did her research. And so I am going to show you the research provided to me when I asked Tom Kokonowski the question of, because Massachusetts is weird. It's not like New York in many, 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 many ways. All right. She said the guilty pleas were not relevant to the charge of murder. Do you think that could work for them or against them? See, I told you I can't read my notes. So I was right about that. The Commonwealth, or actually the clerk was right. The Commonwealth wanted to exclude the guilty pleas from being introduced into evidence. And it was more of an issue if Brian Walshe was going to have to testify. And that's why the judge had to do so much research about this. The judge found that the defendant failed to show how the guilty pleas are relevant to the murder charge. She also found that if she were to introduce evidence of the guilty pleas meaning guilty pleas of lying to the police and the guilty pleas of disposing of or conveying away Anna's body or remains, that there would be a risk of introduction of extraneous factors as to the murder charge. And also that if she were to allow them to talk about his guilty pleas, the jury might be back there thinking, oh, well, he's already going to serve time on those other charges anyway, and that could influence their decision on whether or not to find him guilty on the remaining charge of murder 1, right? I don't know if this is directed to me. Dawn says, so if the jury does find him guilty of murder 1, you're going to be disappointed? I don't think... I don't have any horse in this race, Dawn. I don't have any horse in this race. And so the jury's decision is the jury's decision. I will not be disappointed either way. I'm just a legal analyst. And on this one, I have no skin in this game. I do not feel hella strongly about what he did or didn't do. What matters to me is whether or not the Commonwealth has proven its case. Lexi says it's better for the defense that the jury doesn't know, in my opinion. The defense was about to do too much. Less is more in this case from the defense. Also, they got to preserve their right on appeal, right? They got to preserve their appeal. A lot of you think they're toast. A lot of you think he's toast. And a lot of you think they didn't prove their case. And you couldn't send away a man to prison for life without the possibility of parole, without having seen more. Rosie says the jury needs to know that he pled guilty to lying to the police and conveying of her body. Otherwise, they're being duped and the con man wins. Listen, the defense wanted it in. The defense wanted it in. They wanted it to look like he was owning up to what he did. Because remember, we heard Alyssa say, that's interesting now. We heard Alyssa say that Anna told her she just wanted Brian to own up to what he did and just serve some time so that they could be together. And maybe that would have been, maybe Larry Tipton's going to use that in his closing. Well, he can't now because the guilty pleas aren't coming in. That he did own up to what he did by disposing of her remains because she died in her bed and he was afraid for his children. Is it a stretch? Same. Jebby says, I'm really happy to let the jury decide this case. Me too. should be coach says he's going away. He's going away either way because he needs to serve time on the federal charges. And he's already been away for 3 years. He's been in custody in Norfolk County, Pokey, ever since he was arrested. All right, here it is. In Massachusetts, not all lesser included charges are automatically enumerated on a first-degree murder verdict slip. The judge has the authority to determine which lesser included charges should be listed on the verdict slip based on whether the evidence provides a rational basis for acquittal on the greater charge and conviction on the lesser charge. While second-degree murder is statutorily established as a lesser included offense of first-degree murder, other potential lesser included offenses like manslaughter must be evaluated case by case based on the evidence presented. The judge may include these charges on the verdict slip, even over objection from both parties if the evidence warrants such instruction. No, the ones he pleaded to are not lesser included. No. The research goes on to say that the judge has the final say and the judge has discretionary authority over what goes on the verdict slip in the end. But here's the standard. Massachusetts follows a well-established standard for determining when lesser included charges must be included on verdict slips. A defendant is entitled to an instruction on a lesser included offense of the charged crime when the facts could support the lesser offense. The specific test for inclusion requires that the evidence provides a rational basis for acquitting the defendant of the crime charged and convicting him of the lesser included offense. The test to determine if an instruction on a lesser included offense is required does not depend on whether there is an objection by the defendant or the Commonwealth, but rather whether the evidence supports the giving of such instruction. Importantly, Massachusetts courts have held that judges may provide lesser included offense instructions even when neither party requests them, if the evidence warrants such instructions. So anytime there's a rational basis in the evidence to do so, the judge gets to make the final decision. The statute of first-degree murder is defined. The statute defines first-degree murder as, quote, murder committed with deliberately premeditated malice aforethought or with extreme atrocity or cruelty, or in the commission or attempted commission of a crime punishable with death or imprisonment for life, while murder, which does not appear to be in the first degree, is murder in the second degree. Okay. So as a matter of law, technically murder 2 is supposed to be included as a lesser included for murder 1. So even if the jury thinks, well, we didn't see any deliberate premeditation or extreme atrocity or cruelty, but we think he killed her, then they could acquit on murder 1, but convict on murder 2. You see how that works? Yeah, right now they're taking a break. They're working on the charging conference and jury instructions. And we are looking at the law or the case law in Massachusetts and what could be included on the verdict slip. We won't know until the end. The statutory language clearly establishes second-degree murder as a lesser included offense of first-degree murder, as it encompasses all murders that do not meet the enhanced criteria for first-degree murder. However, the statute does not mandate that all possible lesser included offenses must be enumerated on verdict slips, leaving this determination to judicial discretion based on the evidence. So the answer is we don't know the answer yet. But I'm sure the judge has done all the research. I'm sure she's going to have a well-reasoned decision. We'll just put the clock back up so people don't get worried that we're not on top of it, because we're always on top of it. Except that's when we got to take this down and put the other one up. Jenny says maybe they are going on consciousness of guilt. They were talking about that jury instruction, and we will know when we know whether the judge will provide a consciousness of guilt instruction, and they will read them to the jury in full. So I can look up the model instruction, but again, the judge has the right and the discretion to change the wording of the model instruction if she doesn't like it. And you heard the Tracy Cusick, who is another ADA, the third, the other female sitting at the prosecution table. She is the attorney who argued. She seems to me like the law person. There are people have very specific skill sets as attorneys. Some can do it all. Some are better in court. Some are better on the law. She likes to argue the law, it seems. She's the one who argued the motion for the findings, required findings. I think, is she the one who's going to be doing the closing? Because she seemed to be the one doing all of the arguing about jury instructions. And her name is Tracy Cusick. And the jury hasn't heard much from her because she has not examined any of the witnesses. And so I'm not sure if it's Ann Yaz who's going to do the closing or Tracy Cusick. I couldn't make the voice out when the person just said, who's going to do the closing? I am. Thank you, Sandy. Sandy said, yeah, I know Tipton said he was closing, but I'm wondering who's closing for the Commonwealth. Sandy says, I think reasonable doubt is going to bring a not guilty on murder in the first. We will have to see if lesser included come into play. Well, so tell me that. How about this? If you were one of the people who voted not guilty on murder in the first degree because you don't see premeditation or extreme atrocity or cruelty, I mean, we can all agree that dismemberment after the fact is extreme atrocity or cruelty. We can all agree that that is something horrific. But it has to be extreme atrocity or cruelty in the actual murdering. If you were one of the people who found not guilty of murder in the first degree, do you still think he murdered her? That's the question. Maybe we'll do another poll at the end, so think about it. Thank you, Sandy, for your 5. No, 3 says, do you think the jury knows about the guilty pleas as they were right before jury selections? No, they weren't supposed to be watching any media from the time that they were selected to serve on the jury until the day the trial started. Well, the day jury wait, hold on. You're right. It was the day jury selection started that he pled guilty, right? And so that day they were told not to watch any media. So I don't know what they know. I don't know what they know. I mean, that's a good question. That's a good question. Thanks, Senator 3. I don't have any thoughts on that. I don't know. If the jury decides to, any of the jurors decide to speak out after the verdict, maybe we can ask them. Carbon Offset says, can Tipton argue during closing anything that didn't come into evidence? No, he is limited to, yes, it has to be evidence-based. It has to be things that were proven at trial, things that came in. He can't just all of a sudden start pulling out things that were not in evidence. That is completely improper and would be objected to, and the judge would not be happy. Excellent question. 302 girl, I think he was involved, but I don't believe it's been proven beyond a reasonable doubt. So I would have to say not guilty. Thank you for your thoughts. And for your super chat, for your 10. Cosgrove's Velcro Sneakers is here. Man, you guys have the best usernames. You figured out how to change them back, and I commend you for that because nothing gets by you. Okay, what's next on the docket? I need to know. Listen, we're fluid here. We are as fluid as a trial. We could pick a trial, and then all of a sudden the person takes a plea. You know how many LawTubers and other streamers were so upset when Brian Koberger took a plea because they were planning on like spending so many months covering that trial, and then it was just poof, gone. I like to be spontaneous. And so the time between now and the new year is typically slow in courts. So if you guys have thoughts or ideas, or you know for sure that a trial is starting and that it's going to be televised, that we can get a feed on it, I love your emails. Send it to me. Send them to me. We can always pivot and start covering it right away, because that's what we do here. We pivot, right on a dime. We're like super flexible like that. The virtual juror says, I would need to be swayed away from not guilty murder 1, but motive talk. Okay, Brian lost community status and friends, a frustrated federal case delay, kids, commute. Anna wanted them in DC, a breaking point. Brian diagnosed narcissistic personality disorder, opened the door, in my opinion. That did not come in, though. Did that come in at the trial? Brian's previous diagnosis of NPD? Because we know that from pretrial, but I don't think it came in. So I don't think they can argue that. And again, virtual juror, you know more than the jury knows, right? And so it seemed to me from Melissa's testimony that Anna didn't want to leave Brian. They hadn't had sexual relations in a year. Alyssa didn't know that Anna was having relations with William Fastow. But it didn't seem from Melissa's testimony to me that Anna gave Alyssa the impression that she wanted to leave Brian and make a new life with William Fastow. It seemed like Anna just wanted him to get his act together so they could all be together. Yeah, Lexi didn't hear anything about the NPD, right? There's been no evidence presented to me that he was ever a violent guy. There was a stipulation read into evidence about his federal charges that they were, wire fraud and white collar crimes that do not involve violence. And one day during lunch, we watched an interview with a reporter who did a deep dive into Brian and his past and spoke to a lot of people who knew him who didn't even want to be named, and said, I can't imagine him ever doing anything like this because he just wouldn't want to get his nails dirty. Remember yesterday we saw him looking at his nails when he was in I don't know if it was in TJ Maxx. And so I could feel Anna's frustration. I totally get it. She's the breadwinner. She's the one doing all the work. He's sitting at home with the kids and also has a nanny, by the way. And they also go to daycare every day, by the way. So what is it exactly that you say you do here, Brian Walshe? And his mother is paying their rent? Like, it's kind of got to be emasculating for him, number one. But then at the end on redirect, when Alyssa threw in that stuff where she said, oh, she told Brian that she was not as much as in love with him. He was always asking her how in love she was with him. And she told him she wasn't as much in love with him anymore because he didn't say I love you a lot to her. And, she was the only one who said it to him. And so he asked her if he still loved her as much. And she was like, yeah, no, not really. Not so much. Because, based on everything that's happened, that kind of like snuck in there in redirect. And so, but I still don't feel like Alyssa, who was supposed to be like a sister to her, like her best friend, like Anna wasn't telling her the truth about the affair. So Anna had secrets too. And maybe Anna wasn't always 100% truthful. Yeah, I think she said that on the fly, Robin, because I think she wanted to help. I think she wanted to help convict Brian. But remember, her sister and brother introduced her to Brian. And I feel like they were all to Brian and Anna. So I feel like all of them were friends. And I feel like that poor Alyssa doesn't know what to think. Thank you, Friend of Dog, for gifting 10 memberships. You're awesome. And to all of you who were so randomly gifted and so kindly gifted, welcome. Right. And Brian's mom never liked Anna. That came out. Never wanted her in the picture. Thank you, Friend of Dog. You're super generous. Brilliance is here from South Africa and says, hi, Melanie. Not sure if I missed it, but did the Commonwealth prove any DNA belonged to Anna? Or if Brian's DNA was on any of the items, where are all the buckets that he bought? Well, we saw some pictures in the basement. We saw some blue buckets in the basement. I don't remember if we saw the orange buckets, but remember the buckets he bought yesterday? Not yesterday, but we saw the video yesterday, I think, from Home Depot. And he bought like 5 orange buckets that were watertight and had lids on them. Where are they? And the DNA of Anna, let me go back to my chicken scratch type notes. That was DNA day. What day was DNA day? Today's day 9, so that was day 7, right? And we didn't even find out the results until the very end of the day. We sat through a lot of witnesses. So here's what we found, and this is what my notes say, and obviously you can always correct me if I'm wrong. On the interior of those men's slippers, I call them the men's slippers, there was 3 contributors to the DNA on the inside of those what look like men's slippers. And it was like, I think they found both DNA. Now I can't. It was 270 million times more likely that it was Anna Walshe and 2 unknown contributors. And it was 12 quintillion times likely, which is a 1 plus 18 zeros. I did write that down, to be Brian. So it seems like Brian and Anna's DNA were found on the interior of those men's slippers. Didn't say if it was blood, didn't say if it was touch DNA or skin cells, right? So we don't know. And then on the interior sleeve on the Tyvek suit, but again, it didn't say which Tyvek suit. Was it the medium or the extra large? Because now we know he bought 2 different sizes. On the interior sleeve, there were 3 contributors. Anna and Brian were both of them. One was like 4.8 nillion and one was 100 trillion. So both of their DNA was found on the interior of the sleeve of one of the Tyvek suits. Then there was stain A on the exterior pant leg, which they say was Anna's. We don't know what the stain was. And then there was stain D on the interior of the Tyvek suit. That appears to be Anna's. And then there was a tissue that was found. There was a tissue that was found in the trash. And my notes are unclear. I think it was, my notes are unclear. It says 30 nillion, but I didn't write Anna or Brian. It was the XL. Kim says it was the XL suit. They showed the tag. Okay. So the XL, thanks, Kim. Kim, nothing gets by you. Was that the only Tyvek suit that they tested? Was the extra large one? Did they ever find the medium one? Oh, see, the jury is going to be out back there for hours. And then the basement floor, there were 2 contributors to stain K on the basement floor, which was Anna's. And then on the blade and the handle of the hacksaw, the blade and the handle, Anna's DNA was found. And then on the white towel, Anna's DNA was found. On the piece of carpet, Anna's DNA was found. The head of the hatchet, Anna, and the handle of the hatchet, there were 2 contributors. One was Anna, and the other one, I think they couldn't test. And then the tape with the gauze around it was determined to be Brian. But then there was testimony about whether DNA could transfer to items if they were all in the same trash bag and or if they were in the trash compactor. A lot of people say DNA doesn't lie. The jury might be like, well, everything was all in the same bag. Anna's DNA was all over the house. She lived there. What else was in the garbage? Was it also regular household garbage? Thank you for tuning in from South Africa. And pre-super chat. And CPU Bod 1 is here. She's Tom CPU's sister. Shout out. She says, been busy, missed it. Will there be closing arguments today? No, tomorrow. Love you with all of my heart. Melanie Maz in chat. Love you too. Tomorrow. Today we're waiting for the attorneys to come back to talk about the jury charges and perhaps the verdict sheet. So we are waiting. Ms. V, USMC, Semper Fi, says, so the Commonwealth did full extraction and those in itself don't prove murder. What is being allowed in, then what is being allowed in isn't showing guilty of murder one. Thank you very much. And also thank you for gifting 5 memberships. A lot of gifters today. You guys are very generous. Thank you. Tracy Cooley coming in with a 5 says maybe he put the medium suit on Anna to help keep the blood spatter down. Maybe he did. Thanks for your 5. Aunt Bibi is here and says DNA day was like going to the dentist without Novocaine. I know. It was a lot. It was a lot. Love you too, Aunt Bibi. Kazi's Thesaurus is here, and his opinion is, or her opinion is, the medium suit was for mom, for his mom. Thank you. Thank you. Kelly, thanks for your 20. Kelly PCG says, I think he's going down. I believe there's enough evidence coupled with the jury hearing he's already a felon or being charged in federal court. I realize juries aren't supposed to consider that, but it's in their head. A lot of things are in their head. For example, like when a witness answers a question and then there's an objection and then the judge sustains the objection and strikes the record, the jury's already heard it. They're not supposed to consider it, but they've already heard it, right? Holly says, I wonder if Brian's kicking himself now for pleading guilty on the 2 charges. Based on what we saw from the Commonwealth, I don't think they could have even found him guilty on either of those. Interesting. It's always a gamble, you know? Trial's always a gamble. Leaving your fate in the hands of 12 strangers is always a gamble. And the court is back. Maybe. Well, they're just showing us the bottom of that clock now. You are getting sleepy. If you're on a big screen, this could be putting you to sleep or hypnotizing you. Dawn says, imagine the amount of hate it takes to do what was done to Anna. Commonwealth didn't provide evidence of the mom's involvement. Well, look what happened with Donna Adelson. How long did it take the FBI to get Donna Adelson? 10 years? I think they're trying to hypnotize us, says Music to My Soul. Kay Willis is here. We've been chatting. They're still on their break, okay? So if you left when the judge and the attorneys are taking their break to look over their research, then you didn't miss anything. If you weren't here this morning, you totally missed everything. Brian Walshe is not testifying. The defense has rested. The jury's been sent home for the day. Tomorrow morning, we're going to have closings, and we may have a verdict before the weekend. This trial is a lot shorter than we thought it was going to be. Originally, they said it was going to be 4 weeks. Thanks, Hannah, for your 20. DNA testing on the recovered rug and towel from the dumpster was a statistical match for Anna. We saw him buying rugs, towels after, I believe the Commonwealth provided a lot of circumstantial evidence of his guilt, and we'll tie it in closing. It'll be an interesting closing on both sides. Thank you so much for your 20. It's probably a fake pendulum, somebody said. Tick. It is mesmerizing, isn't it? Nico says, maybe Brian bought the medium suit by accident or thought he could fit into it and then had to buy a larger size. I thought of that too. Great minds. Debbie says, if the jury finds not guilty, Jebby, if the jury finds not guilty, maybe they will go after mom. Kimmy says, when I cleaned out my rental property, I bought 2 Tyvek suits, latex gloves, goggles, and contractor trash bags. I'm sure the sales clerk is wondering when my trial will be on YouTube. Thank you. Thank you, Thatu. There's no dismemberment. It's improper conveyance of a body. There's no body found. Thank you. They're gonna have the jury's gonna have all the photos with them also. All the photos to bring into the jury room and to look at. And Scotty says, it's a ways out, but are you tracking New Jersey versus Sean Higgins? That's the guy who was drunk driving and killed Johnny Hockey and his brother, the Goudreau brothers. Thank you for watching from Canada and for being a hockey fan. And my heart breaks for the Goudreau family and their wives, their widows, and their children, and their mothers and their fathers. And happy holiday to you too. Holidays. I have not been checking on that in a while. Is he still in custody? That is the case that I'm thinking of, right? Because I remember his name was Higgins. Thanks for your super chat. What about the psychic? Right. What about the psychic? I'm going to take a look into it. I know that there have been a couple of Zoom hearings, right? Not even really recently on that, Scotty. But if you have any info and links you can send me, please send them to my email, which is in the show notes below, fanbase@mlittlelaw.com. And we're back to the fan and the coffered ceiling. Gigi gifted 5 memberships. Welcome to the 5 of you who were gifted, including Jenny in Georgia, Marley Worm, Barbara Neely, and Rollins, and Walks with 2 Dogs. Welcome. Thanks, Gigi. Gigi, feel better. Hannah says, Melanie, my assistant came into my office just now and leaned over my second screen and said, oh, what type of hat is stylish Melanie wearing today? Oh, this is a Dead & Company. Hold on. Let's see what we have here today. Dead & Company Playing in the Sand 2019. Oh, yes. Dead & Company. Does it say Dead & Company? Yeah. Dead & Company was it with John Mayer in 2019? It had to be. It was in Mexico and it was awesome and it was Playing in the Sand and it was 3 concerts on the beach in Cancun at an all-inclusive resort. And it was a lot of fun. Thank you very much for noticing. And for your super chat. And your assistant is brilliant. You should give him or her a raise, Hannah. Mitzi buys Tyvek suits about once a year. Let me see something. Where are my photos, my evidence photos? Let's see. I have the sound up, so if they come back, I will hear them. But I just want to go back to the picture of the tools, because this is a picture that the jury's going to have with them in the jury room. I'm sure this will spark a lot of conversation. So here's the tools that were in evidence that they showed. And I'm no Dexter, but a lot of you have watched Dexter before. And so, I mean, we can't really see this very well, but it looks like this hacksaw has had some use. I mean, is it the exact hacksaw that he bought? I don't know. It's hard because this is kind of a grainy photo. But of all the tools, that one looks like it's the most used. And these do not look, to me, to have any wear on them, really. I mean, maybe he used this for the rug. Remember one of his searches where can you identify a body with broken teeth? Yeah, or is it the chemicals that they used in the lab? Right. I don't know. I think somewhere there was a picture of just the hacksaw. I don't know if I have it though. Let me see. They didn't really talk about those gray slippers. I mean, the gray polka dot slippers, were those ever tested? You know, and what I liked about the Commonwealth putting in their case is that even when the evidence wasn't in their favor, they still presented it, even when nothing was found, which I thought was unlike what we've seen. And here's the towel. I mean, I'm not a forensic scientist. It looks like blood to me on this towel. But remember, this stuff was given to the medical examiner and they found no human tissue. Does that mean anything? To you? Denise says, I think Tipton's going to be magic for his closing. Cricket says, why is it bright red when it should be almost black? Right. I mean, I'm not a forensic scientist. That's what I'm saying. And usually, is dried blood usually that red? Is it misleading? I don't know. Because all the stuff that I saw on that, what looked like, you know, a kill room floor, looked to be bright red to me. And everybody's saying that's not blood. Blood doesn't dry in that color. That's rust. Helena says fake blood, real blood dries brown black. Well, there you go. So what is that other red substance? Crystal Justice said, this looks like movie props. Are we being played? I need so many answers. Now you guys are thinking it's fake blood. So I'm going, you're thinking. Marcello says, yeah, I wouldn't be able to convict him on first degree. Summer says, I want to know if the buckets are in the backyard buried. Hannah says, just because the Commonwealth prosecutors were corrupt in the Karen retrial doesn't mean every case they try, they're pinning it on a suspect. Oh, I'm not even going there. I'm not going there. I'm just thinking, like, if this guy's a con man, is he conning all of us into believing that he did it when he really? I don't know. Maybe I'm overthinking it. Maybe I'm overthinking it. Sammy Man says, yes, it looks just like the gallons of fake blood sold all year online. All right, so wait, let me bring that up again. So if that is not blood, if you guys are telling me, because this is, when did they do this dumpster dive? Days later, right? It was like maybe a week. Maybe it was a week after she went missing, that you're saying that real blood would dry red blood. What is all of the red staining? Did they test that? Yeah, why no ring cams in the neighborhood? That's right. The canine did search the backyard and didn't hit on anything, right? The dog searched the backyard except the area where Brian's dog was caged and barking at the cadaver dog. Law enforcement could have had Brian's dog moved to search that area. Yes, I agree. Jay Michael says, I feel that Cohasset did a good job on the investigation. MSP seemed to have minimal investigatory impact. Well, we don't know what they did, but we do know that many of them testified at the evidentiary hearing. And so they did have more, they did have their hand in it more than they let this jury know. And I think, I mean, I'm pretty sure about this, that they knew that calling anybody from the MSP would be a problem because it would open the door into other poor investigations and perhaps Proctor's text messages or Proctor's handling of it. But do you remember there was some testimony about the baseboards. I think it was Connor Keefe who was on the stand. I don't remember now who was on the stand, but there was some testimony about the baseboards, about how in another trooper's report, a female trooper who was not called, her notes said something different than her report, and he hadn't reviewed her notes, so he wasn't allowed to testify about it, but there was no staining on the baseboards on the 8th, and then there was staining on the baseboards on the 9th. Do you remember that? I wonder if Larry Tipton's going to make a big deal out of that. Right? Remember that? The staining on the baseboards that was there on the 8th, but not on the 9th. Yeah, hopefully they'll clear up their timeline and have like some sort of chalk. Oh, congratulations, Marley. You got him a gifted membership. She says, thanks very much for my gifted channel membership. I'm on a tight budget right now, and this is a lovely holiday gift. I am blessed. Congratulations. Dallas Bell says, love you, Melanie. Love this channel. Love all the cupcakes, but I feel like I'm in the Twilight Zone with so many of y'all not thinking guilty on murder one. No, I mean, there's people who think it's a slam dunk on murder one. I think there are all kinds here. They said they were due back at 10:30. It's 11:05. She said, if you need more time, let me know and we can come back at 11, but we're in real time and they're not back yet. Maybe the copy machine broke. I don't know. Yeah, if we were all the same, it would be weird, right? That's right, Jessica. It'd be like an echo chamber. Ashley Rose says, sloppy police work. The police saw the trash bags and the plastic in the trunk, and they didn't collect that evidence when found. I don't know what idiots are in charge of the detectives in Norfolk County. Well, also, do you remember who was it that said he saw some trash bags in the basement and he kicked it with his foot and he thought there was carpet pieces in there, but he didn't open it? Okay, we're back.
You see it, go to the non-session, turn off your cell phone, please.
Your Honor, we're back on the record in the matter of the Commonwealth versus Brian Walshe, indictment 2023-0091.
All right. Let me make some space over here.
If anybody comes in confused, just tell them there's a scroll along the bottom about what has happened, what is happening.
So I know you haven't had a long time to look at them, but we'll take a stab at seeing how far we can get today, and then we'll reassess whether we need to charge conference a little bit more tomorrow. All right. So my approach to charge conferences is pretty informal. And so what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way? So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number 1.
Page 1?
I think it is. She just took it.
Are you joking?
No. It's, I'm sorry. Premeditation. I'm sorry. Notes are saying it's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1. That
No, we'd be here forever if we were starting with page.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to, otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section be regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
Mm-hmm. So 15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9.
Yes, counsel.
The instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
What, the breadcrumbs?
Well, why don't you argue, and then I'll let them I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and you'll have an opportunity to rebut.
I understand the admission of the exhibits. And I understand the admission of the hacksaw. But to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used. That is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant, throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was a search.
There is a knife above the.
Here's the problem with the setup of this courtroom is that because the prosecutor's bench is in front of the defense bench, it's kind of like attached to the judge's bench, which is so weird. Don't even get me started. Every courtroom I've ever been in has the benches side by side. You know, so you have the defense, the prosecution on the left, the defense on the right, or vice versa, whichever way the state works. He can't hear what she's saying. And she's directing her argument to the judge, so he can't even hear it.
Say knife just now because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say.
We're going to take it back because she did talk about a knife.
And the searches were
Repeat myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to.
The searches regarding getting DNA off of a knife, but there was no DNA found on the knife, is what he's arguing.
Remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant, throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was a search.
There is a knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And then
regarding.
It was, the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question. There is a slate.com article
Right.
that the defendant went to that was regarding getting, can DNA be removed from a knife?
Yes.
Then the dishwasher is,
Following that, right?
follows that, and it's, can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's Exhibit 79, is that right?
It's Exhibit 79.
All right.
And then page number 4, the DNA off of a knife,
Yes,
It's page 578.
let me
That's-
get there.
Okay.
I'm there.
Okay. Then if you go to page 670,
Hold on, I just want to look at these.
sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a night? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together, when was the Vinton's Liquor is also on the first, it's at night, because I remember it being a little dark. What
Yes,
time is
Your Honor,
that?
it's dark at the at Vinton Liquors.
5:30, 4:30,
Oh,
something like
5
that?
p.m., Your Honor.
All right. Okay,
And so if you were to go to page 670,
yeah, let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 1:52, also before the,
Been in liquors.
right,
And then on page 671, there is record 2433. Is it possible that a knife that
which
this-
had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
Yes, Your Honor.
Mm-hmm.
And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
Yeah, but you know what else? None of the troopers were intellectually curious enough to click on any of those articles to see what the results of those articles said, right? Didn't they admit to that? And then the HIV search comes in. Was that a search that just auto-populated? Was that something that just popped up? Was that a suggested search? Does that have anything to do with it? I'm not going to jump that far, but nobody who evaluated the phones and the forensics clicked on any of the searches. So bizarre. Take that back a second.
And so,
And above it, does the dishwasher soap?
yes,
Contaminated with, which
this-
had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
yes, Your Honor.
Mm-hmm.
And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
Mm-hmm.
So I think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see what our argument is that those searches show the reasonable inference that a weapon was used.
All right, there are the breadcrumbs. Attorney Tipton, back to you.
Well, I'm not going to repeat what I said. I understand the breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language, but as you know, the whole issue of speculation is handled quite completely in other parts of the instruction, but I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, you know, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns. And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction,
Yes,
and
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense, I lifted it from your instructions and at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence, they have through stipulation, right?
Yes, Your Honor, that
sentence is okay.
it's on the next page only for the limited purpose, and I suggested
I see,
limited
I
purpose.
see, I see. So does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose and.
Well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
Then maybe it should be out.
Good.
I mean,
agree.
it's no longer impeaching him, and
We didn't take
the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right. My present ruling is that's whole section's coming out now.
Thank you,
The
Crystal.
reason the impeachment by prior inconsistent statement is now in italics is, I'm sure that happened with some witness, but I'm not 100% sure.
I don't think it did, at least. as far as
Anybody?
I don't want to speak for
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said
Yeah, I
previously.
just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday, Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So is that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objections.
All right, that's why it was in italics before.
I mean, can you believe
Your Honor, then the
the
impeachment.
prosecutor and the defense attorney in a Norfolk Superior courtroom actually agreeing to something and getting along and being kind and respectful to each other? And the judge is also being kind, and she runs her courtroom. And I don't always agree with her decisions, but I do respect that she absolutely researches everything and spends hours doing it. So refreshing.
By defendant's prior bad act. Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether,
Great.
where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but
Right.
I mean, it's arguably.
What about the lying to his federal probation officer?
That would appear to be a bad act, arguably a subsequent bad act, but
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes, we
Attorney
are, we
Tipton?
are.
But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walsh,
Well,
and the lying to the probate? So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
yes.
Okay.
But
Do you want that to be included? So in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number 4, prior and subsequent bad acts. That's what you were referring to, Attorney Tipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
yes, Your Honor, I was anticipating there to be a proposed other instruction like you had, but yes, I
Okay.
would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder.
The guilty pleas are not coming in.
I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he was. He pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
To clarify, the jury is not going to find out that he pled guilty to the improper conveyance or disposal of a human body or remains, and they're not going to find out that he pled guilty to lying to the police, but they will find out that he pled guilty to the federal charges, just so we're clear.
Yes.
Let me take a minute. All right, so if I say something along the lines of, the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walsh and or lying to his federal probation officer. So all four things would go into that parenthetical.
Good.
Okay. And then, then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right. What do you think?
He's going to be sentenced for his guilty pleas after the verdict because the sentence on lying to the police is going to depend on whether or not he's found guilty of first-degree murder or second-degree murder, because lying on a life imprisonment case to the police gets you more time than if he's acquitted. So that's why they're holding off on that. Great question.
About that, Kamala? All right. What do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud, and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walsh, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
Okay, I want to hear that again because I was confused by that. So my understanding is that the guilty pleas to the disposing of the body and the lying to police are not coming in, but she's saying this is how she's going to instruct the jury, okay?
Now facing is I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud, and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walsh, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
Right. She's going to tell the jury the only thing you are to decide and the only thing he is charged with is murder. You've heard evidence that he may have disposed of the body. You've heard evidence that he may have lied to the police. You've heard evidence of the federal charges, but you are not to consider that as evidence that he did commit the murder. Okay? That is why, in my opinion, Brian Walshe decided to plead guilty to those two other charges. It was strategic. Okay? There you go. Let's see if they have any argument about this. Because that's what the evidence showed, everything after the
So
fact.
you're not,
Then I go back. I don't think that's appropriate to add the for one thing.
the last two sentences.
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to I don't know what I do about the other things.
No, the guilty pleas are not coming
Because
in.
you can see-
The jury will not know that he pled guilty to those two things. They will not know that. They will be instructed. You may have seen evidence of those two other things, three other things, including the federal charges, but you are not supposed to consider that when considering whether or not he committed murder. They are not going to know that he pled guilty to them because, in the judge's opinion, if they do know that he pled guilty to those things, they may be back there in the jury room saying, well, listen, he already pled guilty to those two things, so he's going to do some time anyway. So let's just acquit him on the murder. You see, it could work both ways. It could be a positive or a negative for the defense.
The issue that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walshe.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Oh. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be objection to the consciousness of guilt, so.
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27. Recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. We can to be continued on tomorrow if we need to discuss it more.
And I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes penny 27. What did I do on that page? Let us see. Okay. That's COG. Who wants to go first with what I got wrong?
That's funny.
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walshe's body. I would just suggest that should be tried to conceal the disposal of Anna Walshe's body. And in the...
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
Correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All
accurate.
right, so what do you want me to subtract?
rather than saying taken steps to conceal the disposal of Anna Walsh's body, it's tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
So you want me to take taken steps to conceal Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the
disposal of
body,
it.
not the
Yes.
disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate. So under the Commonwealth's request, I would delete the 3 words, the disposal of.
Will you add the word tried?
What do you want me to add?
Tried. I thought I heard the Commonwealth asking for tried.
Commonwealth's content with how the court articulated the,
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
in the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
And there I got the language right in the second attempt in terms of what you just pointed out in the earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right.
Cracking us up
Any
today.
other edits to that consciousness of guilt instruction? Recognizing the defendant doesn't want it, and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Yes.
I'm asking that that be included. And I modeled that trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's the district court. And the heading for that supplemental instruction that's included refers to where evidence is of it, where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank intended,
Right.
and that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the prior?
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding this other instruction, because I think just the title alone draws attention to the jury where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear and the instruction says they can't rely on consciousness of guilt evidence alone. And I think it then, since we don't want the instruction in the first instance, at least it gives them better context for how to apply what they may deem to be conscious of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then you may not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after.
Right.
Because
I'm just pressing this supplement. It's primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right?
Okay.
And of course, you know this is coming, so you will, I am sure, as you all, I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is, and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suits your client's argument, including this one. But anyway.
I may, but.
Or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions today?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. I sort of a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome, so I've now changed it. I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing, that I can give them. So if that answers your question, that's how we'll do it. Now, you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Well, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is with a more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they propose. But
All
I
right.
think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving the court a heads up. I don't want to send you something and you would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like this weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want. All right. Anything else on the instructions?
Not from the Commonwealth.
All right.
I would
I really
I'd
didn't
like-
mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes.
That is true. There's no evidence that she did die
I
of
read the
natural
pleadings
causes.
that just came through. And if that is where the line is drawn, and you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean, literally the ones that came through before the defense filed right before I went on the bench. I'm not sure, or the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases. And we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases, but what the court's saying is that you would think the Commonwealth could comment that something about
That there is no evidence that Anna Walshe died of natural causes.
and of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
And I'm responding to something that the Commonwealth represented I'm not going to go into right now. So let's just stick to this if we may. So if the government's allowed to say what I just said, and of course the defendant can argue there's no evidence that there was any homicide or any.
I expect you're going to.
I shouldn't be here, I suppose, but I can once again recite the evidence of sudden unexpected death that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walshe. There's no testimony before this jury that ties sudden unexpected death to Anna Walshe, is there?
Judge, there's,
The Vax card. Say the Vax card.
My response is,
Larry, just say the Vax card. Hold on.
Unexpected death to Anna Walshe, is there?
Judge, there's, when the court asked me that, my response is, the government's case is, using that phrase defense attorneys like to use, it's built on a house of cards, suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game to argue because it's equally consistent. And citing the Eremos and Croft, if you have two equally inconsistent propositions, neither have been proved by reasonable doubt. There is no direct evidence of a homicide. And building on that, we've always said there's no direct evidence that anything that came into evidence, the acts of disposal, the acts of the use of tools, occurred after the death of Ms. Walshe. So why is it that the Commonwealth is allowed to ask the jury to speculate based on their circumstantial evidence? I shouldn't use the word speculate. Reach some conclusion based on nothing more than circumstantial when there's no direct evidence of a homicide. And we can't, is the
They
court.
can met out their burden with that circumstance. The law is clear there. They can met out their burden purely with circumstantial evidence. They can. And their circumstantial evidence with regard to the death, again, are those breadcrumbs and what they're going to argue those breadcrumbs mean from the searches to the
What about Legionnaires?
evidence tree from the bags and other, the other distinctions in the evidence.
All of which, Judge, as we've always argued and we will continue to argue, came after any death. And so the issue is, what is the manner of death? And we now have evidence that from their own medical examiner, that death can occur suddenly, unexpectedly, without injury. And it's up for the jury to decide if they can. What evidence do they have as to manner of death when the real possibility, if not probability, is sudden unexpected death due to natural causes, as Dr. Atkinson testified to? And it's equally inconsistent with a homicide. All we're saying is they don't have any direct evidence of homicide. So why do they get to argue it based on their circumstantial evidence when their circumstantial evidence really might only speak to conduct post-death where the death was not a homicide?
But there's evidence in the record before this jury that
I don't want to interrupt the thought process, but there was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, and so we made it.
so you can make an argument based on circumstantial evidence. That's what they're going to do in their case.
Right.
I presume.
And when we look at the jury instruction, which I'm going to read to you regarding circumstantial evidence after this, you're going to see why I'm mentioning these things. The Legionnaires outbreak, the fact that Alyssa was so sick with the flu and they had just spent time together. The fact that Alyssa said that Anna wasn't feeling well. The fact that her vax card, she was vaccinated because her vax card was in the dumpster. That's all circumstantial stuff that the jury's allowed to infer things from. And again, it's a question for the jury. So I'll read the circumstantial evidence charge after this.
I don't know what the Carmel's going to argue. I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
And I agree, they will.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walshe died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that it was not created after a death. And so since the jury heard all about the not only just the possibility, but the probability that there is sudden unexpected death, that the jury needs to decide for themselves. Could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, and using the language in conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the conscience of guilt. And so the jury gets to decide. And it certainly, the thrust of that argument is they're raising a reasonable doubt. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on the opening statement.
All right?
And that's why I was thinking we might find common ground here.
Sounds like we have.
Pardon?
Sounds like we have.
So as long as we're able to argue that a possible manner of death was sudden unexpected death, I understand that the government's going to stand up and say nonsense. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think
She's
we're
like-
close.
Okay.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another
Thank you, Your Honor.
so that there's no surprises.
There's always surprises.
That's true.
All right. And again, I did not mean to create a whirlwind of activity by my comments. I just think that the idea that they couldn't comment at all about the state of the evidence, I didn't want to leave it there. And maybe the takeaway is I should stop thinking about these things 3 or 4 days before they're going to happen.
She's like, maybe
Go to the
overthink
cases
it.
now. All right. Take a look at the verdict slip. It looks very straightforward to me. I don't think that there's going to be any edits or changes to it. Again, I'll finalize that at the very end, so you'll have plenty of time between now and then to look at it. How long are the parties thinking they're going to need for closing arguments?
No more than 45 minutes.
All right.
That sounds good, Your Honor.
So 45 it is. I won't cut you off in a case like this, of course. I have cut off in other cases when it's a 2-day case and we're on 45, 47, but that isn't this case. And, but just,
Wow. Wow. This was, what are we on today? I already forget what day we're on today. We're on day 9. So there was only 8 days of trial in this case. 8 days of trial. And each attorney is taking 45 minutes for closing. Sounds like if they wanted more, she would have given it to him. She said, I'm not going to cut you off if you go over. Karen Reed trial number 1. They were limited to 1 hour for closing. How many days did that trial go? Close to 30? Over 30? In the 20s? A lot. I don't remember if they were limited in trial number 2, but actually Lally, I remember in trial number 1 got cut off. He couldn't finish his last sentence. They had 1 hour for closing. I said at the time, that's insanity. I stand by that opinion. He needs to get up there and say, there was no homicide. There was no homicide. Well done. Well done. Well done. Let's keep listening.
I know you'll all have a ton of experience, but 45 minutes is about as much as they can take effectively, in my view. So let's try to keep it to that. Well, we will be getting them fresh in the morning, which is good, as opposed to having, a couple hours of evidence in the bank and they're already tired. That's all I have on my agenda. Anything that you need?
Your Honor, would the parties have an opportunity to see the next draft of the court's instructions?
Yes. So I will be going back and editing as consistent with what we discussed. And I will then create a new draft and that will go out to you this afternoon.
Thank you.
Scott, why
I
are
know
you
that-
saying a sensible verdict slip? This is the second comment I've seen fly by on a verdict slip. I haven't heard them talk about a verdict slip at all. Did I miss something? I'm just wondering. I might have, because I've been paying attention to the chat and to trying to digest everything she's saying, but I haven't heard any discussion of a verdict slip. Tell me if I missed it.
Maybe there's some other language you want. I'll consider putting that in the morning. So maybe 8:45 tomorrow so that when the jury comes in, we don't have a big delay if we need to make any changes. And I think that's it. All right. Thank you. One other thing that I want to say is that you can be seated. I very much appreciate the work that you've done in the case to get the case in and tried efficiently on both sides. You picked what you needed to pick as your positions, and I appreciate the professionalism that you've shown on both sides in working with each other. And as I say, I drop into Norfolk County every once in a while as I drop into other counties. You and I, counsel, and I know that this is pretty much the routine of how the courts in the Commonwealth of Massachusetts operate day to day. There's nothing unusual about this case. The level at which you perform is the level at which I see when I travel county to county. And I appreciate the work that you've done on this case and will continue to do on this case.
Thank you.
Thank you.
That's nice. Okay, so she said that the verdict slip should be simple, straightforward.
Matters
Lord,
continue.
they still have time to review the verdict slip today, so we don't know what's on it, but she did say that it's simple and straightforward. And well done, well done. We were talking about jury instructions, so let's take a look here at two of the things that they were arguing about and the Massachusetts pattern jury instructions. The first is the jury instruction on direct and circumstantial evidence. And this is the pattern jury instruction, not the MCLE instruction that she said she does not like. And understand that the jury instructions are so important because they have to be fine-tuned to each specific case. There are things that are crossed off, there are things that are added in, there are things that are tweaked a little bit based on the type of case that it is. And so here's the direct and circumstantial evidence jury instruction. There are two types of evidence which you may use to determine the facts of a case: direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about the fact that is to be proved based on what he claims to have seen or heard or felt with his own senses. And the only question is whether you believe the witness. You have circumstantial evidence where the witness cannot testify directly about the fact that is to be proved, but you are presented with evidence of other facts, and you are then asked to draw reasonable inferences from them about the fact which is to be proved. And then here's an optional example. They talked about this mailman example, and I don't recall if she said that she was going to use the mailman example, but I'm going to read it to you. Let me give you an example. Your daughter might tell you one morning that she sees the mailman at your mailbox. That is direct evidence that the mailman has been to your house. On the other hand, she might tell you only that she sees mail in the mailbox. That is circumstantial evidence that the mailman has been there. No one has seen him, but you can reasonably infer that he has been there since there is mail in the box. The law allows either type of proof in a criminal trial. There are two things to keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you. The second rule is that any inferences or conclusions which you draw must be reasonable and natural based on your common sense and experience of life. In a chain of circumstantial evidence, it is not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. If the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty and that there is no other reasonable explanation of the facts as proven. The evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all the evidence in the case. And then it goes on to talk about each type of evidence has certain advantages and disadvantages. And just with specifically circumstantial evidence, whether it is in the form of testimony or physical evidence like DNA, may have an advantage because it comes from several different sources, which can be used as a check on each other. Its disadvantage is that it is indirect. You must piece it all together and then determine whether or not it leads to a reasonable conclusion about the fact, which is to be proved, like the Google searches, like him going to dumpsters, like the stuff that he purchased. Okay, so there's that. Now let's look at the consciousness of guilt instruction, because that's another important one here. Consciousness of guilt. You have heard evidence suggesting that the defendant blank, and then it says here outline the nature of the evidence. And let's see what could apply here. Okay, here, you have heard evidence suggesting that the defendant may have intentionally made certain false statements before their arrest, right? Because he did lie to the police. You have heard that the defendant may have intentionally tried to conceal, destroy evidence in this case. And I'm not sure if they had something else in there that they wanted to add. Right now, my memory is escaping me. If the Commonwealth has proved that the defendant did blank, you may consider whether such actions indicate feelings of guilt by the defendant and whether in turn such feelings of guilt may tend to show guilt on murder, on the murder charge. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of this case. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty. In fact, for such feelings are sometimes found in innocent people. Finally, remember that standing alone, such evidence is never enough by itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all the other evidence. And again, we have so much division in the chat that it would be so interesting to be a fly on the wall in this jury room, because so many of you have such differing opinions and are hanging your opinions on different facts and different evidence and different video. Yesterday's poll, and yesterday for the poll, it was before the defense rested, but in retrospect, that's all the evidence that we heard. So I find the poll to be kind of accurate, unless anybody wants to change their opinion today. But the poll was, how would you vote? And this was after the Commonwealth rested. Not guilty of first-degree murder or guilty of first-degree murder. We had 3,500 votes. 70% of you came in at not guilty of first-degree murder. 30% guilty of first-degree murder. And still, at this point, we still don't know if second-degree murder is going to be included on the verdict sheet, because we won't know that until right before the jury goes out to deliberate, is what I am hearing. Kyle came in to say, as blood dries, the iron in the hemoglobin oxidizes. It literally rusts. Even before it dries, it darkens. There's a reason why I don't do canned cranberry sauce. Kyle, I think you retired on the job, I think in Texas, right? For a long time. Thanks for your 10. Hannah says, hacksaw blade was 30 nonillion times more likely if it originated from Anna Walsh. A nonillion is a number followed by 30 zeros. That sealed it for me. Hannah, for your 5. Just Joey says, Commonwealth didn't even prove Anna Walsh is dead, much less schmurderized. They didn't even check to see if those dump sites were his regular trash sites. Thank you, Just Joey. Charles from South Africa says, note, this is the court, and our opinion is just that. The only question is, did the Commonwealth prove beyond a reasonable doubt first-degree murder? The evidence is very thin, he says. Thank you, Charles, for your super chat. Tons of fun says, I love your coverage. Thanks for your time. Thanks for being here for 7 months. I think after this, let's watch Larry Tipton's opening. The Watcher says, I'm way behind. I'm so disappointed the defense isn't putting on a case. I wanted to hear Proctor's text, but I guess they are right. The Commonwealth has no case. Thank you for your opinion, for your super chat. You're not the only one who's disappointed that Proctor was not called and that the defense is not putting on a case. And Kyle says, yes, I was in Texas 31 years with Dallas PD. Thank you, Fred, for becoming a member. And Manj, thank you for your super sticker. I appreciate you. And Daphne said, Melanie, you're a smart lady. I'm surprised by your opinion on this one. Well, thanks for your compliment and then your insult. But I guess I don't have an opinion about what Brian Walshe did. I don't have an opinion about whether Brian Walshe murdered Anna Walsh or not. I don't have an opinion. My opinion is based on what I have seen come into evidence, because I know way too much about this case. I know way too much about all of the evidence that was not allowed in, all of the things that we looked at pre-trial, all of the information that I've dug up about Anna and Brian and all of this stuff in their past. And I know too much. And so I don't have an opinion about whether or not Brian Walshe murdered Anna Walsh. I don't. I'm sorry if it came off that way. I have an opinion about whether or not I believe the Commonwealth proved their case, and whether or not you all believe the Commonwealth proved their case. 70% of you said no, that you would vote not guilty on murder 1. Okay. So it doesn't really matter what my opinion is. It matters whether or not the jury believes it. Right? Hannah says, the Commonwealth used circumstantial evidence to infer a murder occurred. Tipton is arguing to allow in speculation that the possibility of sudden death is circumstantial evidence of Anna dying of natural causes. That is speculation. But the medical examiner employed by the Commonwealth of Massachusetts did say that it can happen. Right? I have no idea. I have no idea what the jury's going to do. I have no idea what the jury's going to do. I would never bet on a jury. I don't think I will be surprised either way. I don't think I'll be surprised if he's found guilty. I don't think I will be surprised if he's found not guilty, because I have heard so many arguments from you on either side. Right? Karen Reed was easy. John O'Keefe was not hit by a car. A car didn't hit John O'Keefe. Therefore, Karen Reed was not guilty. That was an easy one because medicine, science. What I didn't see was any evidence that Brian Walshe was ever a violent guy. What I didn't see was any evidence that he really knew about the affair. What I didn't see or hear was any evidence about the private investigator that Brian's mother hired. I would have loved to have heard that evidence. I don't know why the Commonwealth didn't call the private investigator. Brian's mother was never called to the stand. There's so many holes here. Deb said, I would love to have a long lunch with Melanie and this judge. Me too. I would love to have lunch with this judge. What is the sentence for the other 2 charges he pled to if found not guilty of murder? It would be up to 10 years on the line to the pleas, unless he's found guilty of a life felony. And it would be up to 3 years for the improper disposal of a corpse. Jessica said, because we looked that up another day. Jessica said, my Nan says, what does impeachment mean? It's just a fancy way of saying catching a witness in a lie, essentially, and proving that they lied by using their prior testimony against them. Do you guys want to watch Larry Tipton's opening? Because the Commonwealth, shockingly said they are not going to bring up the fact that Larry Tipton said you're going to hear from Brian Walshe, and then they didn't call Brian Walshe. So let's take a quick, if you like, shout out to Trial Channel for cutting up all of the testimony and making it easy to find and watch. Let's watch his opening again now that we have the benefit of hindsight. And shout out to the Trial Channel. Go sub to them because they've got everything parsed. Everyone's testimony in all the trials that they have on their channel. They've got all the witnesses parsed into separate videos. They're the Trial Channel. Look at them. Already up to 42.7 subscribers. Highly recommend. And let's take a listen to Larry Tipton's opening. All the way back on day 1.
And when you're comfortable and have regained your focus, you may be seated.
If anybody comes in and they're confused, just let them know this is a
Now we'll hear
replay.
from the defense for the opening statements. Attorney Tipton.
Thank you, Your Honor. Brian Walshe. Lied to the police. Lied to him on January 4th. Lied to him on January 5th. Lied to him on January 7th. Brian Walshe went to Lowe's and bought tools. Brian Walshe went to Home Depot and bought tools. Brian Walshe, beginning about 4:54 a.m., began a frantic and tragic search that you will hear about. You'll hear the evidence. You will hear evidence that those searches evolved from how best to dispose of body to even darker subject matter. As he wrestled with the fact that Anna Walshe was dead.
Again, there's no proof of him wrestling with anything because he didn't testify. And that was a game time decision. Even the judge yesterday thought he was going to testify today. You know what I'm saying?
That evidence that you will hear will be hard to understand, but it is true. On January 1st of 2023, Jim Mutlow left the family home of Brian and Anna Walshe sometime between 1 and 1:30 in the morning. Anna and Brian Walshe continued to celebrate the news. They went upstairs to the bedroom. About an hour later, you'll hear evidence that Mr. Walshe got up, went back down the stairs to clean the kitchen.
Again, the jury did not hear any evidence of that. And shockingly, to my surprise, the Commonwealth has said they are not going to bring that up in closing. And the judge said that they did have every right to in a limited fashion, and they said they're not going to. Maybe these ADAs for Norfolk County actually do believe that this defendant is entitled to a fair trial. Are you shocked?
You'll see evidence that he looked at his email.
Nope.
You'll hear evidence that he then returned to the bedroom, intending nothing more than to crawl into bed with Anna Walshe, the woman he loved. When he entered the bedroom and began to get into the bed, he sensed something was wrong. You will hear evidence that it made no sense to him. But he nudged Anna, his wife. She didn't respond. He nudged her again, a little harder. She didn't respond. He nudged her now in a frantic and panic reaction to where she actually rolled off the bed.
Nope. We haven't heard any evidence of that. Didn't hear any evidence of any of that. And the only person who could have testified to that would have been Brian Walshe.
You'll hear evidence that now he is panicking and he doesn't understand what has happened and what is happening. It didn't make any sense to him. It didn't make sense that somebody that he had just been with and enjoyed New Year's Eve into New Year's Day would suddenly be dead. You will hear.
Everyone keeps saying that he should have called 911. Larry Tipton is going to give you the explanation of why he didn't. So just hang on a second.
Evidence in this case of sudden, unexplained death.
He said you will hear evidence
hear-
in this case of sudden explained death. Well, they did hear that because he got that out of the Commonwealth's medical examiner, which means he didn't have to pay for his expert to come in. And I think that he thinks that he got enough out of that medical examiner, who actually is an employee of the Commonwealth, that he didn't need to put on a case. Strategic. Will it work? I don't know.
Evidence that it is rape. You will hear evidence that it happens in young people and old. You will hear
It was rare. I don't know why the captions said grape. He said rare, not rape.
You will hear evidence that it happens. Sudden, unexplained death. You will hear evidence that it is rape. You will hear evidence that it happens in young people and old. You will hear evidence it happens in male and female. You will hear evidence it happens during the day and during the night, that it happens to trained athletes. You will hear evidence that it can be the result of both mechanical and or electrical problems within the body. You will hear evidence that it might be cardiovascular, pulmonary, neurological, or other reasons. You will hear evidence that it occurs in people who have never manifested a symptom that something might be wrong. And in fact, you will hear evidence that sometimes the first manifestation that something is or was wrong with someone is the sudden, unexplained. That's the evidence you will hear from this. Sudden unexplained death is known within the medical community and the forensic community. But it is to this day not well understood, and that is the evidence you will hear. And it is not well known to non-medical professionals. And you will hear evidence. Brian Walshe never imagined someone suddenly die. 1 hour he's with her, he cleans the kitchen, he comes back up, and she is dead. You will hear evidence in this case that Brian Walshe and Anna Walshe loved each other. Yes, there was stress in the marriage. Stress born out of a simple problem that took its toll. And that's the pending federal case that had begun in 2018 and was still going forward. And what happened was, over time, Anna Walshe got a job in DC with the support of Brian Walshe. It was a huge stepping stone in her career. It paid twice the salary. And they talked about it. And you will hear evidence that they had to make a decision. Brian could not leave Cohasset because of the pending federal case. So who would take care of the children? Well, Anna worked in DC. Brian would. And he did. There was stress in commuting back and forth between DC and Cohasset. Brian Walshe experienced that stress too. And Anna Walshe and they talked about.
Well, we didn't hear Brian talk about what they talked about, but we heard third hand what they talked about from Melisa, kind of. Yeah, we can do another poll. What do you want the poll to be? How you would vote or how the jury's going to vote? But we still don't know if there's going to be lesser included, so it's hard. We voted yesterday, 70% of you said not guilty on murder one. Let's do a badass affirmation card for the day. Affirmations for a badass. Here we go. I'm here for you. Here's today's card. Boop. Here it is. This is a really good one. I think about this often. The best shit happens outside of my comfort zone. There you go. Best stuff happens outside my comfort zone. Remember that in your daily life. When you step outside your comfort zone, oftentimes that is when the magic happens. You can tell when people are behind in the chat because they're talking about something we're past. Okay, hang on. Let's I'm going to speed him up a little bit because how much is left here? Just a little tiny bit. So if he sounds fast to you, he's on 1 1/4 speed. But we did hear about the stress through other witnesses, right? So we got that.
About it on Christmas Day. Brian Walshe experienced that stress too. And Anna Walshe and him they talked about it on Christmas Day of 2022. And that's what the evidence will be. Yes, there was an affair. You will hear evidence of an affair. An affair does not make someone a bad person, does not make someone a bad mother. Make no mistake about that. But yes, there was an affair, not between Brian Walshe and Anna, but between Anna Walshe and William Death. The evidence will be that Anna Walshe did everything she could to hide that affair. That she did not tell her closest friends, her confidants, some of whom lived in DC, the same person, Melisa Kirby, that she spent December 29th with, drinking and talking about her life. She hid this. Well,
I still want to know why Anna's car was found at the Crossing apartment building. All right, here's what the poll is going to be. Here's what the poll is going to be. Do you think the Commonwealth has proven murder one? The second choice will be any lesser homicide, meaning he actually did a murder or killing, he actually was responsible for her death, or 3, not guilty. Okay, that's going to be what the poll is going to be. I'm going to put it up while this is playing.
He was unaware of any plans of Anna ever telling Brian about the affair. William Festo will testify that they behaved differently in public in D.C. to make sure there was no appearance of the affair. William Festo will testify that Anna Walshe.
Hang on, I just got to get the chat up. I don't know why it's not letting me do it right now.
Walshe told him she would be devastated if Brian ever learned about the affair. Brian Walshe didn't know about the affair. He did know. And Walshe had a crush on William Festo because she told him. And he did not react in a jealous way. And you will hear evidence that over the close to decade that these two people were in love. And all you have to do is look at the evidence and the photograph you'll see of Anna Walshe. And the evidence will establish she is a beautiful woman. And it was not unusual for her to comment to Brian, I had some man look at me today. I think he liked her. That didn't upset Brian, not over a period of 10 years. And when she told him that she had a crush on William Festo, the man who had sold them the $1.3 million townhouse in D.C., it didn't upset Brian. He trusted her. In fact, you will hear evidence from Melisa that Anna Walshe told her, I wish you would be jealous. You will hear evidence that there was no financial issues or problem. Anna Walshe was just got that job in the early part of 2022 that paid close to $300,000 a year. They owned that townhouse in D.C. It was worth over $1 million. They owned whole life insurance policies on their sons in the amount of $1 million each. Whole life that you will hear you can borrow against if you need cash. You will hear evidence that Brian.
Okay, here's the poll. Poll is up. Poll is, oops. Do you think the Commonwealth has proved not murder 1 with premeditation or cruelty, extremist atrocity? They would not allow me to put all of those characters in there. The second choice is Brian took Anna's life, but it's not, doesn't rise to the level of murder 1. We don't know if that's going to be included on the verdict slip yet. Or neither, not guilty. So please get your votes in. We've got 6,000 people here about, and I'd like to see how many votes. If we can get as many as 3,500 like we did yesterday, it would be another good sampling. The Commonwealth doesn't have to prove motive, but juries like to hear about a motive, like, you know, the cheating or the financial issues. And so, yeah, let's get at least 3,000 votes in. So come to your screen if you can and vote. You may need to go to your phone or your laptop to vote. You might not be able to vote on your TV, but come on in, participate. Here we go.
Walsh's mother gifted them money, and actually you'll hear from the landlord of the home that they were living in at the time, that Brian was living in, taking care of the 3 boys, while Anna worked in D.C., that it was his mother who was paying the rent, because that's what grandmothers do.
What? Whose grandmother does that?
There was no financial problems here. They owned investment property in Massachusetts.
All right, I have to take issue with this. That's not what grandmothers do. They don't pay your rent when you're a grown man who's like 48 years old. You're paying $5,000 a month rent for your son and his family because the wife's the breadwinner and you're on house arrest. That's not what grandmothers do. That was he a trust fund kid? I don't know. They really didn't bring that into it. Did he get an allowance? Like, I don't know. It's not what grandmothers do, but and anyway, maybe some of your grandmothers do, but I don't know.
The evidence in this case is that Brian Walshe loved Anna Walshe.
Anna.
You will hear that she spoke of him in glowing terms to William Festo. That she said I want people to see the Brian that I know. You will hear how she talked about her relationship with Brian with Melisa Curtin. And notwithstanding the fact that Anna Walshe was having an affair, she described their relationship as open and honest. He believed their marriage was open and honest.
A lot of people thought in this opening, and I could see it, that when Larry Tipton said this, that their marriage was open and honest, like they had an open marriage, like they were allowed to, see other people, but that never really came out. But we also know from Melissa's testimony, she was not told of the affair. She did not know they were having an affair. This is interesting too. I didn't think of this. Not on the witness list says, I also think that the calls on Christmas were a test run to see how people would react, and then call them again when she was missing again. Why did he search on Christmas Day, Anna Walshe dead, or plane crashes today? And why was there never any argument by the defense that Celebrate is inaccurate? Maybe because it wouldn't have helped them. But, we've got Garino and talking at a lot of evidence in the Karen retrial that Celebrate's inaccurate, that the timestamps are wrong, and that searches go back to the time when you first opened that tab on Safari. But they didn't bring it up. I kind of thought they might, but they didn't. It might not have helped them.
Marriage was open and honest because he loved her. You will hear how she described Brian as her best friend to her friend Melisa Curtin. You will also see evidence of text messages that you may use to determine for yourself if there was love between these two individuals. The importance about those text messages that you'll see is simply that they're dated. The ones you'll see are dated beginning December 25th of 2022, 7 days before New Year's Day. In 12:25, Anna Walshe and Brian Walshe are texting each other, and she is sending him 7 properties, listings, primarily out of Zillow, 7 listings of properties in the greater DC area, Bethesda, Annapolis. They're searching for future.
Well, he did show that, right? He did prove that. They were screenshots of Anna sending him properties.
Investment property. You'll see that, and you'll hear evidence that then she comes up to celebrate Christmas with Brian and their 3 beautiful boys. You'll see on 12/27, now that she's back in DC, these text messages between them. And they're talking about one of their properties. And they're talking about the fact that it, in fact, sold. So now they need to figure out what to do with the proceeds. You'll see on 12/28, text exchange between Brian Walshe and Anna Walshe. Now, she's back in DC. She's not feeling well. She's telling Brian, I don't feel well. So I'm going to stay at home and work at home today in DC. And they joke. And on the text, Brian says something like, well, I guess I'll have to get you a plunger.
I didn't get that. I guess I'll have to get you a plunger. And then she said, well, why don't you get me a Porsche? I didn't get the plunger reference. But again, this goes to the fact that she wasn't feeling well. But listen, there's evidence that Brian's a liar. And there's also evidence that Anna wasn't always truthful either. So was she telling Brian the truth when she said she wasn't feeling well in DC? Or was she lying to him because she really wanted to go out with Fasto? I mean, I have so many questions.
I'll tell you what. I'll buy the plunger. You buy me that Porsche. Why? Because Anna Walshe wanted the Porsche. And what you see on that text exchange, right after she says that, is you'll see postings that he sent to her of the Porsches he'd been shopping for the women he loved. And you'll see in his network that he was shopping for Porsches because she had asked for one. On 12/29, you'll see a text exchange between them where they're talking about a 3-story brownstone that she had found that maybe they'll buy for an investment. And you'll see the text references of how much it cost, the square footage it's up and below. You'll see text exchange between them where they're talking about possible renovations in the future. They are talking about the future. And this is on 12/29. And then on 12/30, simple text between them about her catching her flight from DC to get to Cohasset for New Year's. She texts them out land. And what you see in those text messages are she begins to send Brian pictures of her playing with the boys. Now that she's reunited with the 3 beautiful boys again. And then you see 7 pictures sent by Brian Walshe back to Anna, taken of her playing with the boys. And how do they sign off these texts? You'll see them. Brian says, love you. And Anna Walshe says, love you too.
Yes, little cupcake. The jury did hear about the ransom letter. They traced it to an IP address in Nigeria, and it was stipulated in the record that it was not from Brian Walshe, which was interesting too.
We come full circle in this opening, and now we're back to New Year's Eve. And Jim Mutlow, the family friend, is invited by Anna to come to the house to celebrate New Year's Eve. You'll hear evidence that he was thrilled. He was thrilled to be with 2 people he'd known for years, but he hadn't seen in some time.
We did hear Jim say that.
He knew
Jim,
their kids. 3 beautiful boys. He'll describe how when he drove up in the driveway, Anna Walshe ran down the driveway in her heels, no coat, on a cold winter day to hug him. And then what happened? They all went into the house. And what was occurring in the house? Brian was cooking. New Year's. He was feeding them as they all talked for 4 to 5 hours. And what were they talking about? They were talking about the future. They were talking about investments. Anna Walshe told a story about how Brian had found a ring for her and the whole adventure of finding the ring and buying the ring. She talked about it in glowing terms when she talked about how Brian did that. Mr. Mutlow will describe that for the 4 or 5 hours that he was there, he saw no problems between them. Said that Brian was happy, and Anna was happy. He described the atmosphere as jovial, festive. He described it as loving. As adults do on New Year's Eve, they celebrated with wine and champagne. You will have that box, or at least photographs of that champagne box, where they signed it. And what Anna signed on that box she wrote, "Let's make 2023 the best one yet."
yeah, Anna wrote
She went
that.
on to say,
And Brian wrote on that box, because I looked at it again yesterday, he wrote, "To the best triumvirate of all," like they were all 3 friends. But also, just because Anna didn't want to leave Brian doesn't mean that Brian wanted to be with Anna, right? I mean, there's way too much to talk about in this case.
courage, love, perseverance, compassion, joy, and signed it, love.
Me too.
Nothing was more important to both Anna and Brian than those 3 beautiful boys. They had talked about the problem of the federal case. It was stressful. When you heard in the Commonwealth Open the reference to a divorce search, please understand that the other evidence will be that that singular search occurred between conversations between Anna and Brian about the sale of their property. You'll see that that search occurred about 8:30 on 12/27. And why is that important? The evidence will show that the only time Anna Walshe talked about divorce with William Fastow, she talked about it in terms of Brian and I attempting to preserve the family assets.
And I think that was brought into evidence, right? We heard from Melisa she was not looking for a divorce. That they maybe have wanted to protect their assets because he had not yet been sentenced yet on his white-collar crimes.
Why is that important? Because yes, there was $400,000 of restitution that was going to come due. And yes,
Actually, when he was finally sentenced, it was $475,000.
Brian may have had to go to prison for some time. And what did that mean? It meant that there was going to have to be arrangements, not just to pay the money, which wasn't going to be a problem, but the boys had to move up to DC because Brian could no longer take care of them. and there would be all that added expense. And they went so far as to talk to Robin Howe, their nanny, their babysitter, and ask her if she would consider moving up. So there were expenses. So when you talk about preserving the family assets, you have to decide, how is it that I make sure, how is it, as Brian Walshe will tell you, how is it that I make sure that my wife and my 3 sons are financially secure if I have to go to prison for a day, for a week, for a month, or for a year? That's what they were talking about. And in all of the other digital data.
I mean, he was
the
concerned
Commonwealth
about
is-
their financial security, but not enough to actually like get a job and do an honest day's work instead of pulling a long con. All right, keep voting, you guys. We're only up to not even 1,600 votes. We can do better because this poll is very interesting. Now it's getting really interesting, but let's try and get at least 3,000 votes. Thanks.
Been pouring over for 2 years. You will not hear evidence of any other conversation after this. And you won't hear it from William Vasco. In fact, William Vasco will tell you he had resigned himself to think Anna Walshe was never going to be tried.
Yes, and Fosta wanted to discuss the 1, 3, 5, and 10-year plan, which was creepy to me, but it's just me.
Jim Mutlow left around 1:30. Brian Walshe and Anna Walshe went upstairs. He went back down to the kitchen about an hour later to clean it up. And then the impossible, the unimaginable. It didn't make sense to Brian Walshe. It was confusing. He never thought anybody would believe that Anna Walshe was alive 1 minute and dead the next. And all he could think about were those.
Okay, this is Tipton's explanation for why Brian Walshe didn't call 911, but Brian Walshe didn't tell us that. And remember, the judge instructed the jury in the beginning of the case that what the lawyers say in opening is not evidence. It is not evidence. Okay, so I'm going to take that back a minute.
It didn't make sense to Brian Walshe. It was confusing. He never thought anybody would believe that Anna Walshe was alive 1 minute and dead the next. And all he could think about were those 3 boys. What would happen to their 3 boys now that Anna is no longer here? What will happen if they think he did something bad to Anna? Where will those 3 boys go? And so, he told the story. He told lies. He tried to hide so he could hang on to those boys. Brian Walshe never killed him. Brian Walshe never thought about killing him. He would never think about it. Brian Walshe is not guilty.
And Brian Walshe didn't tell us any of that,
First, once again, why don't you stand up, shake a leg?
right? He didn't tell us any of that. So
15 minutes before the break, but it's been a long little stretch here, so I can either break you now, or we can start the evidence. Does anybody who's supposed to show of hands need a bathroom break? Okay, hold on for 15. All right, we're gonna take a break early, and we'll see you back in about 20 minutes.
All right, for the court, please. What is it?
and that was all the way back on day 1. All the way back on day 1 of this trial, which is now on day 9. And it was only 8 full days of trial. So keep voting, because right now we're up to almost 2,000 votes. I am not covering the Tyler Robinson hearing. Someone asked, but I will send you somewhere. I will send you over to someone who is covering it so that you can get a good, if you're interested in watching it. My girl, Andrea Burkhardt, is the best. And I will teleport all of you over there so that you can watch it with Andrea and tell her I said hi. Anna says, why not Proctor? It would help, I'd think. Well, we don't know what was in those messages, Anna. We don't know. We don't know what was in there. Was he looking for? So if you found out, let's just say, for example, like, and I'm not saying that this is true. I'm saying, what if, hypothetical, in Proctor's text messages, Proctor found nudes of Anna Walshe in Brian's phone, and he shared them with his MSP cronies. would that affect whether or not you thought Brian Walshe was guilty? Might not be. It might not have, it might not have helped. And sometimes it's better to keep it simple and not muddy the waters too much. Although for me, this is like so muddy. But because I overthink. And because I never know what a jury's going to do, and because I never, ever would bet on what a jury is going to do. Megan says they already showed incompetence in the police investigation. Quinn says, thanks. Should we do the poll again today? We're doing it now. Get your votes in. Get your votes in. Do you think, the poll is, do you think that the Commonwealth has proved murder one with premeditation or extreme cruelty or atrocity? Number two, that Brian took on his life, that he actually did commit a homicide. There was a homicide involved and that he did it, but it doesn't rise to the level of murder one. Or do you think that they did not prove his guilt at all? That perhaps he just disposed of the body and that did not do the killing. All great parties are never planned, said Charles when we were talking about pivoting. Thank you. Charlie says, cordial, succinct, hard to believe that this is the same courthouse that Karen Reed was tried in twice. Thanks, Charlie. Your super chat from down under. Hannah says, some outlets are saying that Judge Freniere ruled that Brian Walshe pleading guilty to lying to cops and disposal of body is coming in. Did I miss that? I'm not shocked that they're incorrectly reporting, but Zoe, I know you pay very close attention, and my notes say that she said that it's not coming in. That's what my notes say. Commonwealth wanted to exclude the guilty pleas. And she gave all the reasons why they're not coming in, that it would risk introduction of extraneous factors as to the murder charge, that the jury would be considering other potential penalties for the stuff that he already pled guilty to. The defendant wanted them in, but she said the defendant failed to show how the guilty pleas are relevant of murder. So that's what I heard. But I'm not shocked that it's being misrepresented. I could be wrong. And when I was wrong the other day, when I thought the judge didn't say that the evidence was going to be over. Defense Diaries had a post that it is coming in. I mean, we can rewind it. That's the way I thought I heard it. No, you're going to make me go back and watch it, which is fine because I'll watch it with you again. But my understanding was that I heard her say it's not coming in unless she issued a written ruling. Unless she issued a written ruling. Is there an actual ruling? Is there something in writing? Because she ruled that the Commonwealth can reference that he might have been charged, but not that he pled guilty. I don't even think she said, from what I recall, she said that the jury's going to be told that the only thing there to consider is murder one, even though they may have heard evidence of potential other crimes like lying to the police, like disposing of the body, but not that he pled guilty to it. That was my understanding. But listen, you ask 5 lawyers for 5 opinions and you're going to get 5 different opinions. I think it was like right at the beginning, right? I mean, she may have issued a written ruling. But I mean, we listened to the whole thing and I think she brought it up a couple of times. Hold on. Defendant's bad acts. But then they took that break, right? And then they came back. The dangerous weapon stuff. I can't find it right now, and I don't want to waste time looking for it. If anybody can give me a timestamp on the actual law and crime feed from this morning, it's 3 hours and 38 minutes long, of when she actually made that ruling, because I interpreted it a different way. But I could be wrong, and if I'm wrong, I'm willing to admit it. But I just need to see the receipts. That's just the way that I interpreted from what we heard. David said all of the things that he was talking about was on his plans for the future. She was looking for investment properties. Thank you, David. And Michelle says, I live next to Swampscott. Blue is your color. Oh, thanks for being here for a whole year. Happy anniversary to us. Amon said, when the defense rests without witnesses, does they ever work? Do you mean, can they win a case without putting on a defense? Yeah, because they don't have to prove anything. Their job is to poke holes in the Commonwealth's case. So if they feel at the end of the Commonwealth's case that they did not prove their case, they have no burden at all. None. Zero burden. So yes. Remember, a lot of people think OJ was guilty. He was acquitted. A lot of people think Casey Anthony was guilty. She was acquitted. Oh, Auntie Candy sent defense diaries, did not post that. He sent the same thing Melanie just said. Thank you. See how people come in here and they spread misinformation, and it happens to me too. Maybe they just misunderstood. I'm not saying it was nefarious, but people come in here and then they go in other people's chats like, Melanie said this, Melanie said that, and I never said any of that stuff. Katie Parker says, if he gets off on murder 1, I think he might. What's the possible sentence for the stuff he pleaded guilty to? We talked about that, and I think I answered your question on the fly. It could be up to 10 years, for lying to the police, because it's the same as the witness intimidation statute. And also 3 years, up to 3 years for the improper disposal of a corpse. Sandy says, the guilty pleas are not coming in. Thank you. I just wasted all the time looking for it, but it's okay, because I would do anything for you guys. Oh, thank you. Bob did not say that. See? Bob's post reads as follows from Defense Diaries. Breaking Brian Walshe trial. The defense has rested without calling any witnesses. A substantial ruling. The judge will not be informing the jury of the fact that Walshe pleaded to lying to the cops and illegal disposal of a body. That's a huge ruling in favor of the Commonwealth. Tipton took a calculated risk that the jury would hear this and lost big. Wow. I don't know that it's so damning for the defense, because I think it could also work in the reverse. So you guys let me know what you think. Bob is a criminal defense attorney by trade, and so I value his opinion. I don't always agree with it, but I value it. Sandy said, when he's sentenced on the other charges and or this one, do you think the court will run the time imposed concurrently with or consecutive to his federal term? They've asked for it to run concurrently. That motion has not yet been ruled on, but they have asked that. And he's already been in Pokey in Norfolk County for 3 years. And I think he got 37 months in the federal sentence. You can remind me. 37 months, and he's been in Norfolk County Pokey for 3 years almost. And I don't know, right, I'm not sure the time he spent in jail prior to this trial counts as against the federal time, and I don't know. Doesn't always work that way, so I don't know. That's a great question. The defense has filed a motion asking that it be served concurrently. Kathleen says, after you commented on the bottle like a happy trio, right? Brian wrote that. Something still feels off. A few statements through trial come to mind. I'm feeling the long con. Listen, I mean, all it takes is one holdout, right? To hang a jury. Thanks, Kathleen. The fact that Karen Reed's first jury was hung was shocking to me too, because I thought it was obvious that John O'Keefe was not hit by a car. To me, I thought it was very obvious. Sky, thank you very much for your 10 on Venmo. Says Melanie, thanks for being you. I was named after the Isle of Skye in Scotland. Oh, I love it. I love the name Skye. Thank you for coming back to tell me that. And for your Venmo also from yesterday. You're the greatest. All right, you guys, we are coming back tomorrow at 9 a.m. because tomorrow we're going to here's some jury instructions, and then closing arguments, and then more instructions for the jury, and then maybe the jury gets the case before lunch. We could have a verdict before the weekend. They have each said that they are going to use 45 minutes on closing. And so we're going to see what happens tomorrow. Let's end the poll. You guys got all your votes in? A little less than yesterday, 2,283 votes. And I'm going to 8:45 tomorrow, please. Says, thanks for noticing me. Okay, I'll allow it. Listen, I got to get up early. I got to get all my stuff. I got to get into hair and makeup. But you can see the past couple of days, I haven't even bothered. As you can see, baseball hat kind of day. But, you know, if you make a motion for 8:45 in the morning, I'll allow it. Today, they did start a little bit early, but I don't know if they will tomorrow. All right. Get your votes in. Ready, set, and end with 2,300 votes. 47% of you say that you think that Brian took on his life, but it doesn't rise to murder one. 38% of you say straight up not guilty of taking on his life at all, that they haven't proven it. And 15% of you say that they have proven guilty on murder one. I mean, you guys, what a split decision. You know, think about that. Jury's made up of 12 people with different life experiences. They don't know each other. Texas says, bless you all of a con man is involved. This is how they get away with it. OJ was nullified. Anthony was no common sense. You got to be able to prove your case. The burden is on the state to prove its case. Don't blame me for the United States Constitution. But if you come in here and start calling people stupid, my choice. People are very easily conned. That's true. People are very easily conned. Have they proven beyond a reasonable doubt that Brian Walshe committed murder? I guess JMA thinks they have. Okay, Penelope. All right, you guys. I'm going to send you over to Andrea Barkhart for those of you who want to. For those of you who want to watch the, what is she covering? Tyler Robinson hearing at 1:30. I'm going to teleport you there now. All you need to do is buckle your seatbelts, smash the like button on your way out, smash the like button on your way into Andrea Burkhart. Thank you, Mrs. Bouquet. I love you with all of my heart, too. Emily C. came in the chat earlier. Thank you so much for your super chat. Says, okay, people, I'm at your service today. I lost my voice, so instead of making a video, I'm working on timelines. Tell me what timeline or graphic organizers you want from this trial. And then she was kind enough to put in the chat also her email. And I thought I starred that one, but I didn't. But if you rewind, I put it up on the screen so you can email any evidence that you have so that Emily C. How did Emily C. lose her voice? Is she talking too much? I feel like I'm losing my voice too. All right, I'm sending you to Andrea. Tell her I said hello and I love her with all of my heart. Thank you to the moderators because this is a really hard job what they do because for some reason we have a lot of people that hate us. Let's just put it that way. It is what it is. But, you know, if you don't have haters, you're not doing a great job. So there it is. They're threatened by your critical thinking skills. All right, you guys, stay cool, stay kind, stay classy, do all the good things, stay safe. And I will see you tomorrow morning at 8:45 a.m. Motion granted. Peace out, my friends. Do all the good things and stay safe. Bye.